All right, good morning, everyone. It looks as if we have our live feed running on YouTube, so we can go ahead and get started this morning, and I do apologize for the delay.
Yeah, you guys are good. I have got it going. So I'm going to put you back as a host.
Thank you, Miguel.
When you're ready, Judge.
Thank you, Mr. Lee. All right, why don't we get started by having council make and pro se parties enter their appearances for the record.
I'll go first. I am Mary Lee Souls. I'm a pro se party representing myself in this proceeding.
Thank you, Ms. Souls.
Gideon Elliott for the Attorney General's office.
Mr. Elliott. I'm sorry, Ms. Stevens, you're on mute.
My apologies, I lost that when I switched the screens. This is Anastasia Stevens on behalf of the City of Las Cruces, and city's witness, one of the city's witnesses, Lisa LaRock, was on the YouTube, on the Zoom meeting, but I think she maybe has just stepped off because she knows that she's supposed to watch on Zoom on YouTube now that it's available. Thank you.
Thank you, Ms. Stevens.
Madam Hearing Examiner, I forgot to mention that Keith Herman for the county is running a few minutes late.
I'm sorry, who said that?
This is Gideon Elliott.
I'm actually here, Mr. Elliott. Thank you, though.
Oh, there you are.
Oh, we were all running a little late this morning, Mr. Herman. We had some technical difficulties with the YouTube stream. So,
Well, with that, I will announce myself, Keith Herman with Doña Ana County. And Madam Hearing Examiner, I may have some periodic absences throughout this hearing. I would just request in advance, and I understand I will be bound by any decision or determination made in my absence, and I'll waive any cross-examination in my absence as well.
all right. Thank you, Mr. Herman.
Morning, Madam Hearing Examiner. Jeff Wexler and Carrie Olson on behalf of El Paso Electric. We also have Nancy Burns, who's the Deputy General Counsel for El Paso Electric.
Thank you, Mr. Wexler. Ms. Lynch, you want to go ahead?
Good morning, Hearing Examiner. This is Carol Lynch, attorney for Coalition for Clean, Affordable Energy.
Thank you, Ms. Lynch.
And it looks like I'm the last person left, doesn't it? So I am Bradford Borman, appearing on behalf of Utility Division staff. I'm joined by my sole witness in this case, Mark Tupler.
Thank you, Mr. Borman. All right, so we are on the record this morning in the matter of 19-00099 and 000 and 00348 UT. We're going to start with El Paso Electric's witnesses. Before we do that, I just want to make sure that there are no housekeeping matters that we need to address before we get started.
Madam Hearing Examiner, this is Anastasia Stevens for the city. I have a couple of little ones. Hopefully one will be resolved right now, which is Mr. Edwin Reyes, the other city witness, was trying to get on the YouTube and was having difficulty. And I hope it's just because his timing was off. I just asked him to do that. But regarding Mr. Reyes, over the weekend, I guess it was, or Friday, I sent a message asking that he be taken out of turn because he's going to be traveling tomorrow. And you informally, when the parties consented and you informally granted that. So I guess I'd like to make that official that Mr. Reyes will have the opportunity to testify this afternoon.
Yes, I think we will be able to have Mr. Reyes testify out of order. I think that should be fine. Anything else?
I would just say I did circulate a slightly corrected exhibit list also by email. And I'm sure that we'll be working through exhibit issues. It was an instance in which the list, the language on, I just got it. I'm going to interrupt myself here. Lisa LaRock just sent a message saying that NMPRC website says Zoom is starting at 10 a.m. So maybe we do have a problem.
No, I mean, the YouTube stream
Oh,
should be
Zoom.
on.
Okay,
The Zoom meeting was originally scheduled at 10, so I guess when I changed the starting time to 9, that wasn't changed on the website. But that's, I mean, the YouTube stream is separate.
I will send her your, so that would go back to the link that Anna Kippenbrock sent.
No, that link is for the Zoom meeting.
Okay.
And, you know, we do ask that all of the witnesses who aren't testifying, you know, watch through the Zoom YouTube link.
Yeah. Let me just, before we start, because I don't want to lose either of my witnesses, let me ask them to test it again.
The YouTube link?
The YouTube. It said she's at the YouTube link on public hearings portion of the commission's website. Is that what the right place to be?
I believe so. I don't usually.
I've never, yeah, I understand. This second, she's right there. I know.
I mean, I just pulled it up. It's working.
It is okay.
You didn't give any updated exhibits. Judge, while we're waiting, I would need Ms. Stevens updated. If it's an exhibit list, I don't need it. If it's an actual exhibit, I do.
Mr. Lee, it's an exhibit list, and the problem is that I had labeled my exhibits, two of the exhibits, the physical paper, quote unquote paper, has exhibits 13 and 14 in the footer. The hearing examiner wanted have the numbers, but the PDF document inverted those numbers, as did my list. So if you're looking at the PDF numbers, they're incorrect, but when you actually open up the document for the ultimate record, they're correctly numbered. So depending on how everybody's working, the point is to alert you. And I think I'll be pulling them up at the same time, so it may be irrelevant, maybe functionally irrelevant. I hope it's functionally irrelevant.
Okay. Well,
Thank
I
you.
think we'll get started now. I think that I checked, the YouTube video is streaming. So Ms. LaRoque will have to work that out herself. Since appearances have now been entered in the record in this matter, I would ask Mr. Wexler to call his first witness.
El Paso Electric calls Mr. Dave Hawkins.
Mr. Lee, can you swear in Mr. Hawkins?
Can you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Good morning, Mr. Hawkins.
Good morning.
Will you please state your name and spell it?
David Hawkins, David. Hawkins is Hawkins.
Thank you. And what's your position at El Paso Electric?
I am Vice President of System Operations and Resource Strategy.
Do you have before you what's been previously marked as EPE Exhibit 1?
Yes,
This is labeled direct testimony of David C. Hawkins. Is this testimony prepared by you or under your direct supervision?
yes, it was.
Do you have any corrections?
No,
Is the direct testimony EPE Exhibit 1 true and accurate to the best of your knowledge?
It is.
If you were asked the same questions posed in EPE Exhibit 1 today on the stand under oath, would you provide the same answers?
I would.
Madam Hearing Examiner, I offer EPE Exhibit 1.
There any objection?
This is the city. I have one objection or concern that goes to the revision to DCH 9, which is the amendment, one of the amended contracts, which Mr. Hawkins attached to his rebuttal testimony. And I believe that there are changes in that changes in that exhibit that have not been explained by any witness. And I can ask you about this on voir dire when Mr. Wexler pulls up his rebuttal testimony, but we might want to do it now since they're.
So you don't have an objection to Exhibit 1.
I have a concern about his exhibits to Exhibit 1.
Well, wouldn't that be the Exhibit 2?
He just testified Exhibit 1 is true and accurate to the best of his knowledge, but then in his Exhibit 2, he's going to say that no, DCH 9 was not correct, and he's changing that. And I'm saying there's a change in the revision that neither witness has addressed.
Yeah, and Madam Hearing Examiner, at the time the direct testimony was provided, the DCH 9, which is the Hecate exhibit amendment, was accurate and up to date. That's the testimony that Mr. Hawkins provides in his direct testimony. Subsequent to that, there were some minor adjustments made. We wanted to make sure the commission had the most up-to-date version of that amendment, and that's why Mr. Hawkins and Mr. Behrens attached the amendment to their testimony.
Okay, Exhibit 1 will be admitted.
Mr. Hawkins, do you have before you what's been previously labeled as EPE Exhibit 2?
I do.
This has the title of Rebuttal Testimony of David C. Hawkins. Was that rebuttal testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any corrections to your rebuttal testimony?
No, I don't.
Is the rebuttal testimony true and accurate to the best of your knowledge?
Yes.
If you were asked this questions that are posed in your rebuttal testimony today, would you provide the same answers?
I would.
Madam Hearing Examiner, I offer EPE Exhibit 2.
And the city raises the same objection that there are changes in DCH, DCH-R1, revised DCH 9 that are not explained by either witness, not covered by the explanation that was minimal explanation that's given by Mr. Behrens, which Mr. Hawkins defers to Mr. Behrens.
And so certainly she can ask either Mr. Hawkins about their knowledge of the exhibit DCH R2.
And I'm raising this objection in part because I'm not sure that it really is the right exhibit because neither witness has addressed it.
Neither a witness has addressed the change that I'm going to ask Mr. Hawkins about.
Okay. Well, I'm going to overrule the objection, admit the exhibit, and Ms. Stevens, you may cross-examine Mr. Hawkins with respect to the changes to exhibit DCH 9.
I will do so. Thank you.
Thank you.
Nothing further, Madam Hearing Examiner, we tender Mr. Hawkins.
I believe that the Office of the Attorney General will start cross-examination with this witness, Mr. Elliott.
Thank you, Madam Hearing Examiner. Good morning, Mr. Hawkins. I'm Gideon Elliott from the Attorney General's office. I want to start with if you could turn to page 13 of your rebuttal testimony.
I'm sorry, is this would be the Bates number?
Let me double check. Be page 15 of 41
Thank
of
you.
your rebuttal testimony.
Okay,
And I'm specifically looking at beginning at line 3, where you take issue with the NMAG's recommendation number 5 in creating additional work. You say that it's going to create additional busy work, and it would cause additional cost. It would cause additional costs to be passed on to customers. Specifically, you say that, well, let me just ask you this. Do you agree with Ms. Glick that the commission should have information on the costs incurred and passed on to ratepayers as a result of project delays?
yes, I agree with that. I think there's where I'm saying there's additional busy work. I think that information is available, much as it has been in this hearing and previous hearings.
Well, as part of this docket, each of the Buena Vista and Hecate projects come online. Is EPE willing to provide the commission a reporting on the costs incurred to procure replacement energy in time between when the amendment was negotiated and the time the solar plant came online?
And you're talking about which agreement?
Well, I'm talking about for Buena Vista and Hecate, for each of them. After each of them comes online, is EP willing to provide to the commission, a reporting on the costs incurred to procure the replacement energy?
We would certainly provide any information requested by the commission.
What about as part of its application for future projects? Is this something that EP would be willing to do?
In future, so if I understand your question, in future projects, if there's a delay, will EPE provide? I mean, I'm not sure what you're asking. If in future projects, if there's a delay, if there's a cost impact?
Right.
Like I said, I think that information, we would provide the commission whatever information the commission requests of us. I don't know ahead of time to be able to give that answer because it depends when the delay happens. If you're asking whether that delay would, something need to be changed a year in advance, a month in advance, those numbers could certainly change. I'm not sure where you're going with your question.
Well, let me just ask you, would EPE be willing to do it absent a rule?
I can't answer that without understanding the time frame by which we would need to provide it. If we provided an estimate a year before it happened, that number may very well change a month before a delay happened. You have to base your assumption on current market prices at the time.
Well, let's turn to page, well, let me make sure it's page 10. I think it's actually 12 of 41. And this is where you're discussing Ms. Glick's recommendation that EPE provide information on the project's cost increases. And here you say it's unclear how the commission can require the developer to undertake any specific analysis. And I get that, that's reasonable. But then on the next page, you say that you agree that this could be a benefit to the commission. So let me just ask, do you agree that the commission can require EPE to provide detailed information justifying the requested cost increase?
Can you tell me what line? I assume your page 13 of 41 is where you're directing me to. Can you tell me?
Yes, sir.
Yeah.
I may have, not sure I have my lines correct. Well, 18, line 18.
Line 18, thank you.
EPE starts after the period PPA. EPE believes that these requests would be of benefit to the commission, but it is unclear to EPE how this could be required of the developer.
Yes.
So, but do you agree that the commission can require EPE to provide the information?
Well, I'm going to start from line 14 of page 13 of that same Q&A. And I think Ms. Glick is talking about documentation showing project materials and labor costs. EP does not have that information. The developer has that information. So yes, it would be beneficial. And no, I don't believe unless it was handed over by the developer, could EP provide that to the commission?
So I will just ask, because I'm curious, how does EPE validate the cost increases?
My guess is we're talking about Buena Vista in this particular case specifically. Buena Vista had, there was an implication that Buena Vista would walk away from the agreement due to the economics. And so it became a negotiation between El Paso Electric and Nextera, who heads the Buena Vista project, on a price that that we found to be in the best interest of EPE customers. It wasn't based so much on their labor costs.
So it's just kind of like a rough justice economic, you know, what is the, when you say the economics weren't working?
Sure.
What does that mean? Can you unpack that?
Yeah, so Nextera could have taken their solar panels, which they were selling to us at approximately $20, and their battery storage system, which they were selling to us at approximately $6 a kW month, and essentially defaulted on the agreement, owed EPE the security amount, sold those projects elsewhere to other parties, and more than make up the difference between the security amount owed to EPE.
So generally speaking, and I understand that. So generally speaking, when there is a price increase, is EPE in a position to ask what justifies the increase? Or is that the initial contract?
So the initial contract did not allow for the price increase. We had to create the amended PPAs that indicated the price increase. So Nextera couldn't have come to us and said our prices are up 10%, therefore your delivered price of energy is up 10%. That was not part of the original PPA.
So when they came to you with the new prices, you couldn't necessarily ask them to provide an analysis that showed what had increased.
So they came to us and said that there was, they offered a price to El Paso Electric. I think it was a $4.88 per megawatt hour adder. And with that adder, then EPE would have the project available in the summer of June 2023. EPE analyzed what that impact would have been to bring that project online a year sooner in our analysis, and we negotiated a price point from there. I believe it was understood, and there was a lot of discussions around the circumvention investigation, that the solar panels were not going to be available to bring the project in line under the existing PPA.
And just for the record, when you refer to the circumvention investigation, is that the the federal investigation
Correct.
from I think it was the Federal Trade Commission, right?
I believe so.
Okay. So let me just ask this. Is there anything in EPE's current contracts that with these PPA providers that would prevent the company from providing information from developers on which of its costs specifically increased and how much?
I'm going to object because it calls for a legal conclusion to the extent it's asking for a legal interpretation of the contract.
Well, I would presume that Mr. Hawkins knows if there's something that prevents him from providing information.
I think Mr. Hawkins can talk about his understanding, but to the extent that that's calling for a definitive legal interpretation of the contract, Mr. Hawkins is not a lawyer.
I'll accept an understanding.
Go ahead, Mr. Hawkins.
I'm not aware of anything in the agreement that requires NextEra to offer that. I don't think there's anything in the contract that would prevent me from picking up the phone and asking.
Well, I think what I'm asking, is there anything in the contract that prevents you from telling the commission what NextEra is telling you? As far as you understand.
As far as I understand, I don't believe there's anything between my communications with NextEra that I could not tell the commission. If that came out correctly, I apologize. I don't believe there's anything with my conversations with NextEra that I couldn't tell the commission if asked.
Okay. And I think you touched on this, but I just want to ask it. Has NextEra provided EPE with any information on which specific items increased in cost?
Well, the battery storage did not increase in cost. We know that because the price under the amended PPA did not change. There was discussions with NextEra, there was discussions with other parties that there's been cost impacts due to interest rates, to labor costs, to material costs. So whether that's specific to any equipment, what impact those costs had in relation to the solar panel increase, I don't have that information, but there was general understanding that there was a lot of impacts to not only the NextEra projects, but other provider costs as well.
So just unpacking that just a little bit, there was a general understanding that labor costs were going up. So in that example, did they give you a specific increase in the cost of labor?
No, they didn't.
And for any of those other items, did they give you any specifics as to how it was impacting the overall pricing of the project?
No, their only indication to me on the phone was that they were underwater on this project and they would have to do what's best for their shareholders, which led me to believe they were willing to walk away from the project.
So when they said the project was underwater, that was the extent really of the information they were providing EPE. That and these other statements that the economics of the project, labor has gone up, like sort of a summary statement.
I'm not following your question. There was conversations. I think the circumvention issue was a necessary discussion and the key component to this. If not for their inability to procure the solar panels under the existing PPAs, there would not have been a need for the renegotiation from our standpoint, unless they just flat out said, we're going to walk away from this project. Then EPE would have had to take the steps regardless and analyze. We may have reached a different conclusion, but this was under resource adequacy issues and needs. So it was best to look at the cost impact.
I'm sorry to belabor this, but I just want to fully understand. So what information did NextEra provide to EPE to justify or explain its related cost increases?
Well, number one was the implication that they were willing to walk away from the agreement because they were underwater. They need to do what's best for their shareholders and they could get a better price elsewhere. Number two is that they were unable to get the panels due to the circumvention investigation, and all the producers that I guess in the Asian countries that were being looked at were no longer exporting panels, is what they had communicated.
So when they say they're able to get a better price elsewhere, that presumes they were able to get a better price for panels that they would be installing, right? So were those the same panels?
Well,
that were delayed?
they could have been the same panels. I imagine they have multiple projects going on and they receive panels and they distribute panels to the projects based on certain contractual obligations.
Did EP ever ask NextEra if it would be willing to provide detailed cost information that could be shared with the commission?
No.
Okay. Would EPE be willing to ask NextEra to provide this kind of information if under an NDA?
If commission asked us to request that, I imagine they certainly could. I don't know. This was not a cost-based agreement that was negotiated by NextEra.
Okay. Well, let me just now turn to page 6 of your testimony, which is probably page 7.
This is exhibit 1. I'm sorry, my direct.
This is your rebuttal.
Rebuttal.
Yeah, page 8 of 41. And here we're talking about reporting. And you say that you say that NextEra should have been more diligent in providing formal reports to EPE, and that EPE made repeated requests to NextEra to maintain its commitment to formal reporting. So the question I have here is, do you object to requiring that these reports be provided at regular intervals to the commission?
I think in my direct testimony, I said that EP would support providing those monthly reports to the commission. So I don't.
Okay.
Think
And
that's
so
anything different.
So this next one's probably easy. If there was a requirement by the commission to file progress reports and communications more regularly, do you think that would have helped EPE hold NextEra would have helped EPE hold NextEra to the requirement that it file more regular reports with you?
I think it would have shone a light on NextEra. I don't know that the commission could have forced NextEra to do anything different, but it would have made the process more public.
It might have given you a little bit more leverage. Is that?
I think that could be helpful. Yes.
Okay. So then just turning to the next page of your testimony, in discussing future rulemakings, you indicate on page 7 that many of the provisions recommended by Ms. Glick are not currently contained in any regulatory obligations. But then 2 pages forward, which I think is 11 of 41, you say that you would be open to a rulemaking docket So which of Ms. Glick's recommended provisions is EPE okay with if it was brought up in a rulemaking docket?
You started your question by pointing to page 9 of 41. And I'm not sure where to go on that. I see one sentence to an answer there, maybe that's related to your question. Is it, can you point me to?
Well, let me just simplify it and just say, you indicate EPE is open to a rulemaking docket. Which of Ms. Glick's recommended provisions would EPE support addressing in that docket?
I'm going to go through my rebuttal testimony because I think I address each one.
Okay.
I think the necessity for a rulemaking, though, just as a preface to my answer, is it's hard to without discussion, without all parties involved, to understand when a contract should be looked at, renegotiated, taken to the commission, because I think it's hard to pinpoint the requirement, the request for negotiation, the timing of resources. And I just want to preface it that way. And so I think many of, if I had objections to Ms. Glick's, and I think generally I don't, but to the extent that there were, I think she was, I think we're seeing eye to eye with each other on those, but I think there was issues that we couldn't just sign off on. And let me go to where I address each point. Unless you want to point to a specific point, otherwise I'm probably just going to tell you that I stand by my rebuttal testimony on each of her points.
Okay, that's fine with me. Thank you. I have no further questions.
Thank you, Mr. Elliott. Ms. Stevens for the City of Las Cruces. Do you have any cross-examination for Mr. Hawkins?
Good morning, I do. Well, Mr. Hawkins, how are you doing?
I'm doing well. How are you?
I'm good. I would like to start with the question I tried to ask before your testimony was admitted. Would you look at section J of the new exhibit DCH 9, which is now DCH R1? It's the back of your rebuttal testimony.
Sure.
I'm sorry, what's the bait stamp page number on that, Ms. Stevens? Exhibit DCH1 starts on page 21 of 41.
It is section J on page 24 of 42 on the PDF, and that is 24 of 41 on the bait stamping. I'm not sure where the missing page happened. Are you with me, Madam Hearing Examiner and Mr. Hawkins?
Yes. So, if we can, right, the bait stamp page 2441, paragraph J, or
Paragraph J.
section J, section 12(1)A of the agreement.
Now, Mr. Hawkins, the other changes that were made between DCH 9 and DCH R-R1, those were places where references to other sections of the agreement had sort of gobbledygook in them. Is that right?
My understanding is there may have been some links embedded in the original exhibit that was filed, and this served to replace that exhibit.
Now I'm looking at section J, and my question to you is that the security amount, this is about halfway down the large paragraph A in section J, has now been increased to $15 million. And that's not the number that was discussed in your direct testimony or the application that covered your direct testimony? See that number?
Well, I'm reading, I see a $5 million reference and a $10 million reference. I'll have to read the language.
Yeah, go just above the 5 million, the line above the total is 15 now.
Okay.
It's comprised of 5 and 10. See that?
I'm reading it now, yes.
So what happened between November 14th, when your direct testimony was filed, and February 6th, when your rebuttal testimony was filed, that changed the security level?
Oh, I'm sorry. I looked up. I was reading. I mentioned that I was reading it. If it's all right, I'll read it because I'm not sure. I want to understand what was said to be able to respond to your question.
May I ask you, Mr. Hawkins, are you unaware of a change?
No, I know, and actually I did not handle the negotiations on the Hecate agreement. I was personally involved in the NextEra, the Buena Vista agreements. I was part of the discussions on the changes for the Hecate agreement. So I'm not as familiar with this as I in the Buena Vista. So I'm trying to see where, based on your question, it looks like there's a question of a $15 million reference in this amended agreement and what would be in my direct testimony. Is that?
Yeah.
Okay.
But if you don't know, just if Mr. Behrens or somebody else was Mr. Behrens also sponsors the same exhibit. He does not talk about this change. Is he the right one to ask? I don't want to.
He may be. You just said it was different than what I had in my direct testimony, and I wanted to clarify that.
Well, if you didn't negotiate this, was Mr. Behrens involved in those negotiations?
So to be clear, Mr. Behrens had the communications with Hecate. Mr. Behrens and I were certainly in communication with each other.
Okay, I'll ask him. So let's start with the current status of the two projects. And that would take us to exhibit ECH2R, which begins on page 33 of 42, 33 of 41 of your rebuttal.
Okay.
But this claims to be next year's progress report for January 2023. Is that right?
All right, you broke up, Ms. Stevens. Can you ask the question again?
This claims to be next year's progress report for January 2023. Is that right?
Yes.
And at the top of the page there, it has above Mr. Frere's name, it says January 2023, but doesn't have a specific date. Do you know when in January this was received?
Not from this document by itself, no.
Do you know whether it was received at the beginning of January or the latter part of January?
It'd be information I would be able to get, but I don't have that information in front of me.
Would you please also refer to CLC Exhibit 3 from the hearing exhibit file?
Okay.
And would you agree that that's a similar report dated December 1st, 2022? from next year to El Paso Electric?
It appears to be similar, yes.
If you would put those reports side by side, the December report on the second page asks for a December 31st, 2022 commercial operations date or COD for Buena Vista 2,
Buena Vista 2.
does it not?
You asked me to put the two exhibits side by side and confirm.
Yeah.
One of them
Yeah,
says.
well, look at both of them. Take a look at both of them. I mean, side by side is not necessarily literal. I don't know how many screens you've got.
No, I didn't understand if I'm supposed to be checking both documents for the same date.
Well, look at the CLC Exhibit 3 and tell me whether at that point Buena Vista said that it's on track to meet. Buena Vista is currently on track to meet a 20 megawatt 12/31/22 COD. Do you see that? Middle of page 2.
And this is under the asset onboarding status header on page 2.
Just above the asset onboarding status.
Okay, I see that. Yes.
Okay. And were you aware of that in December 2022? Were you aware of that request or that proposal?
Yes, I think they made known to us that they wanted to have a commercial operation date in December of 2022 at some point in December. Sure.
And did Buena Vista 2 actually come online in by December 31st, 2022?
Not commercially. It's still not in commercial operation date. There may have been test energy. I'm not sure.
And so in the report that's attached to your testimony, that one was asking for a February 28th, 2023 COD. Is that correct? That would be. That would be on page 34 of 41 of your rebuttal testimony.
And at that time, in the same area as the CLC exhibit, Buena Vista is on track to meet a COD for both the 20 megawatt and the 100 megawatt projects. I don't know that it references a date in that sentence.
No, look at the bottom line on that page.
Oh, Buena Vista is formally requesting a phase 2 COD by February 28th, 2022.
Right.
Correct.
And from your testimony that it's not in commercial operation yet, does that mean that EPE did not comply with that request?
No.
Why not?
Because the project is not ready to be commercial at this point. We wouldn't accept it unless it was commercial till it met the full terms of the agreement.
What are the deficiencies in your mind?
Deficiencies. So Buena Vista 2, the 20 megawatt project, I believe, is putting out the full output, but commercial operation can't be declared under the LGIA until both projects are complete. I believe they're doing testing of various segments on the larger facility, and they still need to do battery testing on the larger facility.
And the January 28th report, the one that we have in your rebuttal testimony, the paragraph that you were first reading above the asset on the last paragraph above the asset onboarding line, that refers to an issue, a FERC 203 issue. You see that?
Oh, thank you for telling me it's January 28th. It saves me from looking. Sounds like it was a January 28th document.
I didn't say anything about January 28th. What are you talking about?
Oh, I believe you did in your question, but.
No, I didn't.
Okay. Regardless, I'm trying to find the FERC 203.
That's the last paragraph under panel status and construction. First paragraph above asset onboarding status.
Yes, I'm there.
Yeah.
So your question is,
Is that what is that issue what is holding up bringing Buena Vista 2 online?
no,
And you said that what's holding up bringing Buena Vista 2 online are terms of your LGIA?
no, I said of the PPA. I said the LGIA requires both projects to meet commercial operation together under the LGIA.
And would you refer please to CLC exhibit? I'm sorry for taking this out of sequence, but exhibit 17.
Okay.
Is the, do you recognize this as EPE standard LGIA?
Yeah, I believe this is a template, yeah, which would be probably located on our website for people who wanted to look at our LGIA agreements under our tariff.
Would you look at section 5.9 on page 31 of 98 of that document?
Did you say 5.9?
5.9, yes.
Thank you, ma'am.
Did you, I'm sorry, 31 of 98?
31 of 98, yes.
I'm on 31 of 98.
Does that provide for, does that section of the general standard interconnection provide for limited operation when portions of the facilities are complete, but not all of them?
This under 5.9?
Yes.
It looks like it allows for it, that much like Buena Vista 2 is producing up to 20 megawatts currently, still not under the commercial operation date, but it allows for it to produce energy while construction continues on PV1 and testing continues on PV1.
So let me put it this way. What are the implications of EPE contending that the BV2 contract has not reached commercial operation? Just list them for me. What you said, it's producing power. I assume that power is going into EPE system, correct?
Correct.
Is EPE paying for that power?
I would just have to check the terms of the agreement, whether there's payment, whether it's for free, whether it's avoided cost.
And are New Mexico customers receiving that power?
I think that's an interesting question. It probably requires a legal interpretation of whether this agreement, the amended agreement, is approved or not. If it's not approved, there's probably, I'm not sure how the accounting is taking place on the test energy at this point.
Do you understand that there is a contract from the commission standpoint, there is a contract in place?
There is a contract with Nextera to the extent that the amendment is not approved by the commission. I think there'll have to be an understanding of what contract applies to customers and how all that is rectified.
You have not made any proposals or explanations of that in your testimony, have you? Or
I don't think so. I think this is a good deal for
or
customers.
have you?
I would,
Actually,
can I finish? Like to finish my answer if I could. I think this is a good deal for customers to the extent that it's not viewed that way. EP has not undertaken any other process by which we could acquire a resource in its place, whether that's 4 or 5 years from now, or whether that's power purchased from non-renewable resources to meet its resource adequacy needs.
the city moves to admit exhibit CLC 17 and CLC 3. I'm hearing.
I have a foundation objection, Your Honor. All I heard Mr. Hawkins say was it looks like a template that might be available on the website. And I'm not sure that that's sufficient foundation. I also am not failed to see how it's relevant to have a template that may or may not contain the same provisions as either of the LGIAs that we're talking about here today.
I could clarify that with another question, Madam Hearing Examiner.
Go ahead, Ms. Stevens.
Okay. Mr. Hawkins, is the LGIA with Next Era significantly different? Does it differ from the standard agreement?
Yes, it was a non-standard agreement, LGIA that was negotiated with NextEra, is my understanding.
And the clause that we were talking about, 5.9, was that altered?
That I'm not sure of.
Do you have reason to believe it was altered?
I have neither reason to believe it was or wasn't altered. I don't know without looking at their agreement.
Would El Paso Electric have altered that to the disadvantage of its Mexico customers?
Would El Paso have altered it to the disadvantage of New Mexico customers? No.
Then I again move to admit on the grounds that if EP didn't alter it to the disadvantage of its New Mexico customers, it's our best public indication of what the nature of the terms are, that there is a possibility for interim, early partial operation of a facility.
My objection is the same. I don't, given the answers from the witness, I fail to see how this can make a facted issue, in this case, either more or less likely.
I'm going to sustain the objection with respect to Exhibit 17, but I take it that there's no objection to Exhibit 3, Mr. Wexler?
No objection to Exhibit 3.
Let's go back to your rebuttal testimony, Mr. Hawkins, if I can find it.
I'm sorry, Judge, is Exhibit 3 admitted?
Yes,
Yes.
Exhibit 3 is admitted.
Okay.
Thank you.
That's CLC Exhibit 3.
See ya. I'm on page 3 of your rebuttal testimony, Mr. Hawkins. It's page 5 of 41.
Okay.
And I'm on line 15 to 17. I think this gets to what you were testifying to. And your testimony reads, but if the commission were to deny the PP amendment for BVPPA2, that project no longer would be available to EPE's New Mexico customers. That's your testimony?
That's my testimony there, yes.
And what would happen with the BB PPA 2? It's not available to New Mexico customers.
I don't have a determination on that if the commission were to deny the amended PPA.
Does that mean you don't have a legal determination, or you don't have a physical? You cannot address the physical aspects of that.
By physical, I don't understand what you mean by physical.
Well, if the commission were to let's do some hypotheticals. If the commission were to deny the amendment, would EPE go forward with that PPA and purchase the 20 megawatts of Buena Vista 2 energy from NextEra for the next 20 years?
Yes, I believe that's under the agreement that BV 1 and 2, the amended agreements, are in effect with or without commission approval.
And would EPE take that extra 20 megawatts of energy and apply it to Texas customers' load?
That may be a potential outcome.
Would EPE be in a position to take that extra 20 megawatts of energy and apply it to off-system sales?
I don't know that we've considered that. It is certainly a resource, even with the amended prices that are below current market value. If the commission were to deny either of these agreements, I think the impact would be significant for New Mexico customers as far as a replacement resource and costs, and would certainly be a benefit to another party due to it being below market, and who that party is, if that's Texas, if that's somewhere else. We haven't made that determination.
Would you please look at CLC Exhibit 16?
Okay.
Are you familiar with the FERC approvals that NextEra got in order to achieve operation of Buena Vista 1 and Buena Vista 2?
Where they sought market-based rate authorization from FERC? Yes.
Yes. Are you familiar with that process?
We ourselves have to file every 3 years for market-based rate authorization. So I am familiar with the process.
So are you familiar what specifically NextEra did in the fall of 2022, pardon me?
I believe I have an understanding of it. I don't know. I can tell you my understanding, if that's
okay. That's what I would ask next. Yes, thank you.
Yes. So NextEra created an LLC, which is Buena Vista Energy Center. And for order for Buena Vista Energy Center to sell wholesale power, which they are doing by selling energy to El Paso Electric, who in turn sell it to retail customers, they have to get market approval from FERC. And I think that's what they are requesting in this letter.
And is it your understanding that they were able to get rapid approval because they are selling it to basically the full output to El Paso Electric, a retail utility, rather than putting that power into the market as a whole?
No, if I want to understand your question, when you say putting it into the market as a whole, they would not take on the role of a traditional utility. I'm guessing from your question, they could sell that to any third party who may sell it to someone else.
Can they sell it themselves in the market? from your Otero substation?
Can they sell it to, can Buena Vista Energy LLC sell it to Nextera? the
To a
util-
to a wholesale entity other than El Paso Electric?
Well, we have an agreement with them, so they're not entitled to sell the output of that to any other party.
So you're committed, is what you're saying. El Paso Electric is committed regardless of what the PRC does. El Paso Electric is committed. Is that basically your?
Yeah, I think originally
position?
in the PPAs that were filed, there was a condition precedent that required the commission approval, and that was removed. And so my opinion, not an attorney, but my opinion and my understanding is that El Paso, once this facility meets its obligations under both the LGIA and the PPA, El Paso Electric is committed.
Now, going back to your testimony in response to Mr. Elliott's questioning about your understanding that NextEra could walk away from the project. First of all, did NextEra ever actually tell El Paso Electric that if you don't accept a price increase, we're out of here? We're not going to complete this project.
It was understood. I was on a phone call with representatives of NextEra, and they indicated that they need to do what's best for their shareholders and that they were underwater on this project.
And did that take into consideration the cost that they had already sunk into the Otero substation?
I imagine they would take into those costs into consideration if they're going to make those statements.
Did they make those statements? What was the statement then? Let's look at it this way, because you would, what is the statement that they made that gave you the impression that they would walk away?
Well, that they needed to do what's best for their shareholders. So if the agreement remains in effect with no change to price, that's not in the best interest of their shareholders. So that indicated to me that they needed a change in order to do what's best for their shareholders.
Okay. Do you know how much money has been expended by NextEra on the substation and interconnection facilities to date?
I don't have that number.
Do you have an approximation of that number?
Not in front of me, no.
Would Mr. Davis know that number?
He may, I'm not sure.
Going back to
NextEra was the one who self-constructed their own facilities, and if Mr. Davis has that number, they may have shared that number.
Can I take you back to Exhibit DC R1, R2, pardon me. The DCHR2, the notice and the language about the FERC issue. Oh, I still have it open there. No, I don't. This is back to page. I'm back to page 34 of 41 of your testimony. And that paragraph, it has been conveyed by both EPE and Buena Vista teams that the Otero switchyard was energized and synchronized prior to the transfer of ownership of the switchyard to EPE. Would transferring ownership of the switchyard to EPE involve EPE knowing the value of the assets that are being transferred?
Yes.
And has that happened yet?
No.
So EPE is in the dark about the value of the assets?
No, I just answered that I didn't have that number in front of me, and I didn't know whether or not Mr. Davis has that number.
And again, I'll ask, do you have any sort of approximation of that number? Tens of fives of millions.
Mr. Davis may have a better representation of an approximation.
Okay, let's stay where we are right here on, it's just so much easier than moving pages. The last sentence of that same paragraph. Buena Vista currently is on track to meet COD with requests for EPE to accommodate an earlier COD for both the 20 megawatt and 100 megawatt projects. What is the expected in-service date now?
Well, the COD under the PPAs, I believe, is June 1st of 2023. I know we've had various updates from them and various proposed estimated dates of operation, which haven't been met to this point. I understand now we are looking maybe at the first week in April.
And if I would take you back to your page 18 or 20 of your rebuttal testimony, 20 of 42, line 14 to 15. Your testimony, the BV1 and BV2 projects are scheduled to be commercially available months before the amended CODs of June 1st, 2021. Is that word scheduled meaningful?
Well, to the extent that they are not commercial until they are commercial. So all that can be provided at this point is a schedule.
Explain to me, please, what you mean there. Is there a schedule of the expected date earlier than June 1st?
There was we looked at a schedule on CLC exhibit, I believe it was 3, that had I believe that was the one with the February 28th, 2023 COD. So we've been presented with schedules before, but those schedules obviously are subject to change as they continue with their testing.
Have there been problems with the testing?
There must be issues that they didn't understand. I believe there was a particular inverter that had a manufacturer defect that caused a delay in testing. There were some metering issues that needed to be rectified that they learned through testing that I believe were rectified. Any other ongoing issues, if there are any, I'm not aware of.
And in the meantime, you said that at least megawatts of power is being produced. Is that on an ongoing basis?
Well, they schedule power with El Paso Electric, their expected output, so that El Paso can accommodate the megawatts. And so if they're adjusting the schedules as needed for as they see fit, those schedules would be adjusted. So I can't tell you that it's continuous output every day, subject to the weather, cloudy days. How they're using what they're testing impacts the total output of the energy.
Basically, though, it's running at the 20 megawatt level subject to testing. Is that what you're saying?
It may be. I've seen outputs as high as 20 megawatts. It's not commercial, so if they see the need to test anything under that, I believe they have the right to do that.
You say it's not commercial. That's kind of a legal, based on the legal meaning of the contract.
That's the way I interpret it. The contract requires a commercial operation. EPE has not entered into the commercial operation of neither BV1 nor BV2 at this point.
And when I forgot, I didn't quite get an answer to this question earlier. When that power goes into through the point of interconnection and into EPE's system, what happens with it? How is it accounted for purposes of the fuel clause in New Mexico or Texas, or for off-system sales? How is it being accounted for in the interim?
I don't have the answer to that question. I don't have the responsibilities of the regulatory accounting behind that and how it would be handled.
Are any of the witnesses in this case able to answer that question?
I don't think it was part of anyone's testimony.
Yeah, I don't think it was part of anybody's testimony either, but would Mr. Sheetal know that?
You might ask Mr. Schiestel. I don't know if he knows the answer to that or not.
Okay, let's move on to a totally different subject. And this is something that Mr. Elliott touched upon, but he was asking about your rebuttal testimony at page 14. I believe this is consistent with your direct testimony as well. Offers to provide monthly reports, file monthly progress reports with the commission. Is that right?
And is it 16 of 41 or is it 14?
No, I'm confusing myself and you. This is actually 14 of 41, 12 on the traditional number. When you're talking about Miss Glick's.
Okay, I'm on 14 of 41.
Right. And you quote your on the bottom question answer, you quote your own direct testimony, which says that EP proposes to file monthly progress reports that would include information on the status of, including the reports that EP has received from the sellers. So you're referring both to Buena Vista and Hecate, aren't you?
Yes.
Now, are you familiar with the rebuttal testimony of Mr. Schiestel and Mr. Behrens?
I've read it.
Are you aware that they're proposing somewhat reluctantly to file quarterly reports just for Hecate?
I'm not sure if they're talking about until the construction phase is met in Hecate. I don't know. I think you would have to ask them. I think.
Well, let me ask, which one of the witnesses, do you pull rank on Mr. Schiestel, Mr. Hawkins? I think you're both vice presidents.
If I pulled rank, I wouldn't be sitting here in this proceeding right now.
You'd be doing something more pleasant.
So no, I don't. I am not in the same area of responsibility of either Mr. Behrens or Mr. Schiestel.
So if Mr. Behrens and Mr. Schiestel is offering less in the way of reporting than you are, is your testimony meaningless, or is your testimony contradictory? Because your testimony, when you respond, is your testimony, back to who pulls rank? I think you just said that probably Mr. Schiestel does.
I don't know if I said Mr. Schiestel does. Can we look at his testimony before I attempt to answer?
Sure. Yes, please do. It's EP Exhibit 8 at pages 7 to 8 of 46.
And I'm sorry, so it's 7 to 8 of 46?
Yes.
Okay, I'm on page 7 of 46, and I'm guessing since it carries over, it's the question at the bottom.
Yeah. Mm-hmm. And you see that Mr. Schiestel's testimony position is that EPE would not object to providing quarterly reports to staff regarding the progress of Hecate. Given the advanced stages of Buena Vista, EPE does not see the value of regular reports except if the COD is changing.
Right. So I'm wondering,
I guess my question simply is, what is EPE's position about reports? Your testimony, your own testimony, in response to Ms. Souls and Ms. LaRock is that, let me find the specific language. I'm on page 6 of 41 of your testimony, lines 8 through 12, and specifically the company tries, beginning on line 8, the company tries to be accurate and completely describe all the events. At no point would EPE be misleading. I'm seeing quite different positions on reporting requirements. What is EPE's position?
could I answer your first question and then maybe to the second question? It looks like Mr. Schiestel is responding to a recommendation from the city of Las Cruces. And it appears to me in reading this, without reading the city of Las Cruces' recommendation, that he agrees with the city of Las Cruces' recommendation of quarterly reports. There's no reason both can't be satisfied quarterly and monthly.
Okay. So you're offered to do monthly stands.
And I believe has no objection to the CLC's request for quarterly.
Okay. And so do your offer to do monthly is still stands? I think you gave an and, but you didn't give a yes.
Yes.
Thank you. Regarding the commercial operations date before June, the renegotiated June 1st, 2023 date, your rebuttal testimony at page 9, which we're pretty close to, I think, lines 6 to 9, says that the Buena Vista project was delayed until November 2022 because of a delay in the communications cable. Is that right?
And I'm sorry, I was still on Mr. Schiestel's testimony.
Oh, I'm sorry.
And I'm back on my rebuttal.
You're back on your rebuttal, page 9 of 41.
Okay.
And lines 6 to 9, you refer to your direct testimony on page 8. You say the project was delayed until November. We're talking about Buena Vista now. Project was delayed until November 2022 because of a delay in the communications cable. Is that your testimony?
That looks like my testimony, yes.
And then if you go back to page 8 of your direct, which I believe would be 10 of the page 10 in the bait stamping. Actually, my testimony says page 19. Hold on a second. Let's look for page 8. Page 8 of your direct, which is 10 of 500 page 548 pages, lines 19 to 20. You testify that Next Era and EPE agreed in February 2022 to adjust the CODs from May 2022 to November 2022 2022. Is that right?
That's what it says, yes.
And the city asked you about that change in CODs and discovery, didn't it?
It might have.
Emma, would you please open up CLC Exhibit 4?
Okay.
And did you sponsor this response?
Yes.
City asked for agreements entered into before July 13th concerning extension of the commercial operation date for Buena Vista. And your answer was, the answer that you sponsored was, EPE and Next Era did not enter into any agreements concerning the extension of the COD before July 13th, 2023. That your testimony?
That's my response. That's my response to.
And your responses to discovery are sworn like testimony is that correct?
I would have answered it in the same way, yes.
Okay.
So the difference being the terms of the agreement did not change. There was an agreement that the project could not become available until after we took the outage necessary for the communication cable to be installed. That would happen after the summer period. And so the understanding is that there would be no commercial operation date likely before November of 2022.
So is this a matter of semantics? Because this whole case, a lot of this, the discussion of your testimony, Mr. Barron's testimony, turns on the fact that of what the COD was. Are you saying that the COD doesn't matter? Do you agree not to enforce the COD? What is going on here? Just explain it to me.
Well,
Objection vague. I'm not sure what the question is.
Okay, explain whether or not EPE agreed to extend the COD from May 1st, 2022 to some later date, whether that was November or June 2023, before the agreement was reached in July 13, 2022.
so the COD was recognized by both parties, could not happen until the interconnection facilities were in place. There was an understanding at a point when the communication cable was not delivered on time that the outage necessary for the interconnection facilities could take place prior to, I believe it's the May 1st, 2022 commercial operation date.
Did you say could or couldn't? I'm sorry for interrupting.
It could not. It could not. The outage EP would not take an outage during the summer period for the interconnection to this transmission system. The understanding now from both parties is that this project could become available in November of 2022, but that did not alleviate NextEra from any obligations under the PPA as far as any damages of not meeting the May 1st commercial operation date. This was all done under the existing agreement. It was an understanding of when we can expect the project to come online.
So the understanding was that they were not alleviated from the May 1st, 2022 date?
Yes,
Not going to happen?
all the terms under the original PPA were still in effect.
The city moves to admit CLC Exhibit 4.
Any
No
objection?
objection. No, ma'am.
CLC Exhibit 4 will be admitted.
Now I'd like to take you back to your direct testimony, Mr. Hawkins, which I've of course misplaced. And I am on page 12, which I think is probably 14. Oops.
12 of 548? Are you?
Well,
is that the
I'm
base?
trying to figure that out myself. I think it's page, well, it's 14. Yes, it's page 14 of 548. And this is what you say, you do refer this to Mr. Behrens, but this is your discussion of the status of possible remedies. And specifically, you testify that in the spring of 2022, there had not been any default. Both NextEra and EPE agreed that no force majeure had occurred, and there was no basis for daily penalties. Are you saying that this was based on the fact that you had agreed not to pursue anything around the COD of May 1st, 2022, or because of the fact that is this statement based on the agreement that you just, the understanding that you just testified to, that it wasn't going to happen until November 2022?
I'm having trouble following your question.
You just testified that there was an understanding that in reality, Buena Vista was not going to come on until November 2022 because of the timing issues around the interconnection. Is that right?
That's correct.
And you also just testified that all of the terms of the actual contracts were still in effect, both PPAs. Is that right?
Yes.
So what is the meaning of this statement that when these discussions were being held in the spring of 22, there had not been any default? Both NextEra and EPE agreed that no force majeure had occurred, and there was no basis for daily penalties.
So I'm talking about the amended agreements, and you're asking me when we had conversations that were under the original agreements. That's where I'm confused. The November was under the original agreements. This paragraph talks about the amended agreements.
No, this paragraph talks about when the discussions were being held before there were amendments. Well, I shouldn't be arguing with you, but my understanding is that this talks about the circumstances under the existing agreements because it was in the spring of 2022 before there were amended agreements. Does that make sense to you?
I'll answer how I understand your question. There was conversations that I had with NextEra whether this was a force majeure event. They answered no. That was the same understanding that I had from EPE's legal advice on the issue. They had not, at that point, missed the commercial operation date. Well, let me take that back. They had not. The negotiations started in April, although I don't think they had missed the commercial operation date. There certainly was an understanding that they were going to make the commercial operation date. So after May 1st, fault damages would have begun, but not at the point when the conversations were initiated.
And at the point when no basis for daily penalties also? That also require, in your mind, missing the May 1st COD?
Well, like I said, this was when the discussions were being held. That's what I say as beginning on line 2.
And when were those discussions being held, Mr. Hawkins?
We received notification of the circumvention, I believe, the end of March. And I believe it was in late April that they notified us of the impact to the project.
When you say of the impact, that was the request for the 488 $4.88 increase in the price.
That may have been on that date, or it may have been an issue on supply chain issues as a result of the investigation. The 488 conversation may have come at that date or at a later date. I'm not sure.
Would you
I
please
think-
refer to?
Ms. Stevens, we actually have passed the 45-minute time limit for cross-examination. Do you,
Okay, let me just ask him to, may I just ask him one more exhibit here?
yeah, yes.
And that is. Did we admit CLC 4?
Is there any objection to CLC Exhibit 4?
No objection. I thought it was already admitted.
I thought so.
Oh, actually, it has been admitted. I'm sorry.
Okay, then I'm.
It has already
then
been
I need to
admitted.
move down a bit to. Oh, yeah, in the context that we're doing, would you please look at CLC 5, Mr. Hawkins? This relates to what we're talking about now, what was going on in the spring of 2022.
Okay.
And this one is sponsored by you. So you have seen this before. And you were aware in the spring of 2022 that NextEra had actually offered to make delay damage payments to EPE regarding the interconnection facilities deadline. Is that right? You provided this?
I did provide it. I'm moved to the next page on the exhibit.
Right.
So I see, is it under the seller's interconnection facilities milestone?
Right.
Where they offered to reimburse $42,000
Yeah.
on a 14-day delay.
So they acknowledge that there was a delay.
Which it looked like they cured in 14 days. So to the extent how curing that delay in regard to all the other provisions of the contract, Mr. Behrens may be a better witness to answer that.
Do you know whether EPE accepted that payment?
Of the $42,000, I'm not aware if we accepted a payment.
City moves to admit Exhibit 5, City Exhibit 5.
No objection.
And with that, I think, let me just take 1 second here to make sure. I guess I would ask, is there really kind of an administrative notice come exhibit question, Madam Hearing Examiner? Mr. Hawkins testifies about the prior reporting that El Paso Electric has done to the commission, and exhibits 13, 14, and 15, which I mentioned earlier. 2 of them have kind of garbled labels. Those include the reports that the company submitted in case 21-00159 and case 21-00260 and in case 20-00194 UT. They're all commission filings, and they really are administrative notice type things. But while I've got a witness who spoke to compliance with the commission, I'd like to ask to admit them if you want them admitted, or else for administrative notice of them.
You're asking about exhibits 13, 14, and 15?
Right. They're all filings with the commission, compliance filings with the commission.
Okay. I'm gonna have to review those, and I mean, there does have to be some presentation with respect to relevance, which I haven't. Ms. Stevens, what I'm going to say right now is that I'm going to admit Exhibit 5
CLC Exhibit 5. And we are now going to take a 10-minute break. So we're going to go off the record until 11:01 a.m. Thank you.
Thank you. And thank you, Mr. Hawkins. Appreciate it.
Sure.
Mr. Wexler, do you need rough drafts at the end of the day?
No, Mr. Lee, I think we're okay. We don't need the rough drafts. Appreciate it.
No problem.
Okay, we are back on the record in the matter of 19-00099 and 00348 UT. Before we continue the cross-examination of Mr. Hawkins, I just wanted to state for the record that no requests were submitted to Ms. Kippenbrook of the Hearing Examiner's Office for public comment during the hearing today. So no verbal public comment would be taken during today's hearing. I believe we left off with Ms. Stevens' submission of exhibits 13, 14, and 15, which are documents contained within the e-docket filing system of the PRC. And the issue is, with respect to their admission, is what their relevance is to this proceeding, since these were in other docket numbers. Could you address that briefly, Ms. Or is Ms. Stevens back?
I'm real. Pardon me, Madam. Pardon me, Madam Hearing Examiner. I've been here. I just didn't realize I was not here. And let me take you to where in Mr. Find it now. In Mr. Hawkins' rebuttal testimony, he talks about. Sorry, maybe it's in his direct. Must be in his direct testimony.
I mean, can you just describe it
Oh,
without
yeah,
going back and forth to the testimony?
Yeah, Mr. Hawkins testified that the company has kept the commission informed, alludes to those reports and talks specifically about a conversation or meeting that the company had in April 2022 with staff about the status of the projects. So I wanted to put the context around his testimony there about that was a conversation with staff, obviously not with the other interveners here or on record with the commissions. I just wanted to put the paper record around that, what was filed with the commission in that time frame. And those filings are January, March, and June of 2022.
How are these related to the Buena Vista or Hecate
Well,
projects?
the last one,
15, are you exhibit
I believe
15?
it's I feel make sure that my numbering got screwed. Yeah, no, actually, no, the 14. No, my number. I'm sorry, this is my problem. My number 13, which is table 14 in the website. Problem with my numbering. Say the last one chronologically is the one that should be labeled 13, but is actually in the PDF is labeled 14. That's the report in case 20-00194. That's the actual disclosure of the new CODs for both of the projects, Buena Vista and Hecate. The other two are requests and dockets that are responses and dockets that the commission opened on its own to track its own concerns about the abilities of all three IOUs to meet their summer resource needs. And the point there is that the company made generic statements about supply chain problems without specifically disclosing that either project was behind schedule, not going to come up.
And so with respect to the numbering,
I'm
what
sorry
is
about
the
that.
reason that the numbering that is on the exhibit can't be?
Oh, the problem with the numbering is that the PDF names, I guess I changed this somewhere midway and I didn't change the PDF name when I closed it. But if you actually open the exhibits, the footer and the big number, CLC number, first page on the one that said the PDF says CLC exhibit 14. If you open it up, it says CLC 13. And that's what I assume when we end up with a paper, when Mr. Lee makes up the exhibit volume of the transcript, that's what's going to show. Now, I could change them all again. It doesn't really matter, but for purposes of consistency with what's going to be in the physical record, the physical, such a thing still exists.
So the
Permanent record.
title of the document doesn't match the exhibit number marking on the exhibit. Is that what you're?
The title of the exhibit and the title of the exhibit on the exhibit itself and the description match. It's the little PDF name that is incorrect in terms of this PDF number. So where it says CLC exhibit 14, case 20-00194, it should say CLC exhibit 13 and vice versa for CLC.
Okay, why don't you correct those tonight and or during lunch? Why don't you correct those during lunch and re-upload them?
Will I be able to do that? Because I'd be happy to. I didn't know that.
Yes,
Accent.
just please do that. Correct.
And is there a way to remove the old ones, or can you do that even beforehand or afterwards?
I can do that.
Okay, thank you so much. Now, are you granting the request for administrative notice?
Well, why don't you correct them and then I'll take a look at them during lunch.
Okay, I apologize.
So if we can proceed on the cross-examination of Mr. Hawkins, we would be moving to Ms. Souls. Ms. Souls, are you prepared to proceed with your cross-examination of Mr. Hawkins?
Yes, Madam Hearing Examiner, I am.
Okay, go ahead, Ms. Souls.
Hello, Mr. Hawkins.
Hello, Ms. Souls.
Earlier, Mr. Hawkins, when you were responding to Mr. Elliott of the Attorney General's office, you indicated that you expected that NextEra would walk away from the Buena Vista project unless there was a price increase. You recall that exchange?
Yes.
What provisions in the PPAs would have allowed NextEra to walk away?
Default provisions.
The which ones?
Default. They would have defaulted under the agreement.
Are you able to point me to a particular part of the PPA?
Would you like to look at the PPA and we can go through, I guess, the various provisions of not meeting their times? Mr. Behrens may be able to give you specific details, but if someone doesn't perform under the agreement, I don't know that there's language laying out I don't think there's going to be specific language saying that they can walk away without paying damages. So I would just point to all the damage provisions that they would be responsible for if they chose to walk away.
Would I understand correctly that the default provisions mean that they saw El Paso Electric as being in default?
No, I believe they believe themselves to be in default.
And with their being in default gave them the opportunity to walk away? Is that your understanding?
And they would be responsible for all the provisions under the agreement if they chose to do that, yes.
And when you calculated the delay damages, was that the calculation of what their walking away would result in?
I don't believe so. I think those delay damages were only a 1-year delay of 2023 to 2024.
Did you, Mr. Hawkins, or anyone at El Paso Electric calculate what Buena Vista would have to pay you if they walked away?
I don't know that it needed to be calculated. I think we would have gone to the PPA agreement and looked at, I think it would have been capped at the security fund amount.
And how much is in the security fund?
I would have to look. I'm thinking it's around $15 million under the original PPA. That may be just one of the agreements. I know it was raised under the amended PPAs.
So somehow, do I understand correctly that Buena Vista, NextEra, was in default and yet they had the upper hand in this negotiation?
I don't know that they were in default.
I thought that's what you told me a minute ago. These were default provisions.
Well, they weren't in default. I think that those provisions would happen if they walked away. They would have defaulted.
At that point in time, did you understand either NextEra or El Paso Electric to be in default of the provisions of the PPAs?
At which point in time?
At the point in time that you engaged in a negotiation to pay more for the Buena Vista energy.
I did not understand them to be in default. I don't believe they felt they were in default, but I believe the potential was there for them to default if not negotiated.
All right, let me ask you again, because this started with my asking you as to what were the PPA provisions that would have allowed them to walk away. I thought your response was the default provisions. Is that correct?
Well, those are the remedies for default. They could, a party in any agreement could just walk away. I suppose it doesn't have to be between EP and NextEra. You could have a contractor working on your house that chooses not to show up to work. They've defaulted on whatever agreement you had. Why they chose to do that and your financial arrangements with them, I'm not sure it's spelled out exactly what allows them to walk away, but the fact that they walk away would lead to default.
And Mr. Hawkins, do the proposed contract amendments address the possibility that NextEra would walk away?
Would walk away from the new agreement or the old agreement?
Well, I think the new agreement is the contract amendments. Is that correct?
So the contract amendments, they still have the ability to walk away. We've just increased the security amount such that if they chose to walk away, it would cost them more money. And then I believe we put in a provision in there that if they chose to walk away, EPE would be able to look at taking on the project to completion.
Do I understand you then that the original contracts did not provide for El Paso Electric to take over the project if NextEra chose to walk away?
I would have to look at the agreements of the original ones.
And your engagement in the negotiations, did you consider that as a possibility?
I don't believe we considered that as part of the negotiation.
Do you see that clause in the proposed amendments as providing additional protections for New Mexico ratepayers?
I believe that was the best we were able to negotiate.
Do you think that was a successful negotiation?
Well, the project's almost here, so hopefully that had some impact on it.
Project has been almost here since November, has it not?
I don't know what you mean. I mean, they started construction long before November.
Would you go to your direct testimony, please, at page 9 of 548? Line 16.
I'm sorry. I want to make sure it's rebuttal.
No,
Yeah, I'm
I
sorry.
went direct, right?
Yes, you are. I'm sorry. I
Okay.
landed rebuttal. Okay, 9 of 548.
Yes, sir.
Okay, I'm there.
In line 16, you state that EPE has frequently been on site at the Buena Vista project's location to perform work required by EPE to allow for the interconnection of the Buena Vista facilities. Is that your testimony?
Yes.
And what work did EPE have to perform to allow for the interconnection?
Mr. Davis can address the specific work. It's in his area that the interconnection work was done.
Were network upgrades required for the Buena Vista interconnection?
I believe so. I'd have to look. To me, it makes sense that there were, but without checking, I can't give you a definitive answer.
Would Mr. Davis know that?
Mr. Davis may know that. I certainly believe there were network upgrades, but I can't say that I for sure know what was or what cost impact those may be.
And then my question that follows, which is, when did El Paso Electric complete the required network upgrades? You wouldn't know that either, is that correct?
Mr. Davis would be able to give you more specifics.
Very well. And was EPE responsible for any other interconnection work?
Any to another party?
Between the Otero substation and El Paso Electric's transmission system?
No, well, when we talk about the interconnection, that's the ability for the generating project to interconnect. So that would have been the Buena Vista 1 and 2 being responsible for the interconnection of that project.
Then help me understand. It's my understanding that NextEra was responsible for the Otero substation. Is that true?
That may be true. I'd either have to look at the interconnection agreement, or Mr. Davis may know. My understanding is that they did construct the Otero substation, but subject to Mr. Davis confirming that.
Very well. On page 10 of 548, at line 12,
Yes.
you referenced scheduling an outage. When would that outage have had to happen to meet the original May 1st, 2022 commercial operation date?
I understood the outage necessary, and again, subject to Mr. Davis' answer on this, I understood it to be an 8 to 12 week outage necessary for the interconnection work to take place.
And are you telling me to ask Mr. Davis as well?
You don't have to, but
If I really want to know. Do you know when El Paso Electric did take the outage?
I believe it was either, it could have been early October.
And do you know how long that took?
Again, that might be a better question for Mr. Davis.
Very well. I'm catching on. Thank you. Please go to page 11 of 548. At line 3.
Line 3.
Well, this doesn't look right. Yes, it does. You reference El Paso Electric's meeting with staff on April 18th.
Yes.
What issues did El Paso Electric identify at that meeting?
I believe the discussion was around summer of 2022 resource adequacy.
Did you talk about the issues that led to adjusting the commercial operation date to November of 2022?
Yes.
Was that change to the COD, was it based on interconnection delays, not solar panel delays?
The November 2022 was based on, and I think we went over this in the questions with Ms. Stevens. It didn't by contract extend the COD. The contract did not change, so I think there was an acknowledgement by both parties that the actual commercial operation, the date of that couldn't be until November, but it did not change the date of the agreement in which penalties would take place if that was not met. So I'm not sure if that was in your question. I understood that maybe in your question.
Did El Paso Electric and NextEra document that understanding that the COD was moved to November of 2022?
No, that was more of under the, and they may have under Mr. Davis's contacts with the interconnection facilities on new dates on when the actual construction could be completed. But that was more of a understanding that they would not be taking the outage necessary, and that outage would not begin until after the summer period. And so it was an understanding that the earliest that those projects could have come online would have been in November of 2022.
But you just referenced the interconnection agreement, which I understood is distinctly different and separate from the PPAs. Is that correct?
Can you tell me when I referenced the LGA in regard to the question of November 2022?
Yeah, a minute ago, you referenced the interconnection agreement and Mr. Davis.
Yeah, I believe that's when we were talking about the obligations of the substation work. Unless I miss, that's what I recall the interconnection agreement to be around, and Mr. Davis could talk about that.
So the November 2022 COD date, is that a PPA date or an LGIA date?
Well, the PPA can't go into effect from a physical reality until the work under the LGIA was completed. The interconnection work needed to be completed. The substation work needed to be completed. Without that work, it wouldn't be possible for the energy from those projects to be injected into the grid.
Would you look at line 16, where you say NextEra informed El Paso Electric in February of 2022 that a change in the COD would be required? Do you see that?
Yes.
Are you referring to a change to the May 1st, 2022 COD or a change to the November 2022 COD?
Yeah, I've seen this. It's sort of bad phrasing, but it's referring to the May 1st, 2022.
Thank you. Beginning at line 20, you indicate that NextEra blamed the Department of Commerce investigation for NextEra's inability to obtain solar panels, correct?
I don't know if I used the word blamed.
According to?
It says was impacting its ability to.
If 20 megawatts of solar panels were already on site, Why would Buena Vista 2 be affected by the Department of Commerce investigation?
As I understand, and I believe I talked about this in my rebuttal, that the projects are together. If, like I said, I understood it to be an economic issue from NextEra's part, that they could take these projects and locate them physically to another site for another customer. And so when they were negotiating the price adjustment, it was for both projects. They could have simply put the 20 megawatts of solar panels, in my mind, back on a truck and delivered them elsewhere.
Did you talk with staff at the meeting of April 18th, 2022 about the Department of Commerce investigation and its potential impact?
I believe we did, although the impact to the projects I don't believe was known at that point. NextEra had provided us an email notifying us on March 31st of the circumvention investigation. But I believe the conversations with NextEra regarding a price increase happened after the phone call with staff.
So in that April 18th meeting, did you share with staff that there were 20 megawatts of solar panels already on site?
I may have, I don't recall.
Who from staff participated in that meeting?
The only name I recall, I believe, is Mr. Sidler. And there was I believe there was at least two other members of staff on that call.
And who from El Paso Electric participated in that meeting?
I believe it was myself, Jesse Gonzalez, who is our manager of resource management, and Victor Martinez, who is manager of resource planning.
Okay. Please go to line 12. Make sure I'm talking about. I think it's on the next page, forgive me. Yes, on page 12 of 548 at line 12. When
Okay.
did NextEra make its initial reserve price proposal?
I believe it was at the end of April.
And what is meant by a reserve price proposal?
So NextEra indicated that to get the panels on site, El Paso would need to pay an increased fee because the manufacturer producers were no longer honoring contract prices. They were selling at market prices to their customers.
How did NextEra justify the proposal given that 20 megawatts of solar panels were already on site?
They didn't. I think that was where additional conversations led to further conversations where they indicated that they would need to do what's best for customers. So initially it was proposed to get secure the remaining panels. And then further conversation cleared up that they were going to put that to the existing panels as well, which led to the discussions that they, in my mind, were willing to walk away from the project.
On page 14 of 548,
Okay.
at line 12, let me know when you're there.
I'm there.
You spoke with Ms. Stevens about this. Did El Paso Electric have a choice as to whether or not to collect damages?
At what point in time are you talking about? If we allowed for default to happen?
Is that what you're talking about at line 12?
Yes. So we had looked at, regardless of if they were looking at a June 2023 or June 2024 dates, which we were talking about, there needed to be an amended agreement, at least in my mind there. So they would have defaulted under the original agreement because they wouldn't have met, they would have gone beyond the delayed damages period. And the most EPE could have collected, it's my understanding, is that 15.2 million.
And that would have been based on forcing them to default. Is that correct?
Allowing them to default, I guess. I don't know that we would have forced them to.
Very well. Please go to page 22 of 548.
Okay, I'm there.
At line 14. Is it correct that both the Hecate 1 and Hecate 2 PPAs originally identified May 1st of 2022 as the commercial operations date?
That may be true. Have to look at the agreements, but yes.
Is it correct that the commercial operations date for both projects then shifted to December 2022?
Yes.
And what was the cause? Why the shift?
I believe this may have been talked about in the RPS filing. So to the extent that information is different, I would fall back there. But my understanding is there was an impact based on the execution date of the interconnection agreement. But that's just a subject to bad memory or good memory.
Is El Paso Electric responsible for that interconnection?
We will be performing, again, another question for Mr. Davis, but I believe we are conducting the work under that agreement, but subject to Mr. Davis.
Very well. How far ahead of the commercial operation date does the interconnection facility need to be completed?
Well, I guess it depends. If the interconnection work should require the generator to connect to the grid, so it should be done before the commercial date of the PPA.
So the Hecate amendments are proposing a June 1st, 2024 date. Is that correct?
Yes.
And how far ahead of June 1st, 2024 would the interconnection facility need to be completed?
And just a clarifying question, are you asking when does it need to commence in order to meet that date, or when does it need to be finished for that date?
The interconnection facility need to be completed.
Prior to June 1st.
Is there going to be an outage required?
Potentially, that would be a question for Mr. Davis as well.
Very well. Back at line 8, you indicate that the Hecate 2 commercial date was extended by mutual agreement to May 2023. Was that only Hecate 2 and not Hecate 1?
That's what my testimony says there. I would have to look at the Hecate 1 as well.
And when did this mutual agreement take place?
Let me look at the footnote. I don't have that information in front of me.
Is the agreement in writing?
Well, it looks like Mr. Schiestel testified to this. I footnote his testimony there. So Might be in that docket where it was explained.
But you don't know.
I don't know.
Please go to page 28 of 548.
Okay.
Now, this does not look like what I was looking for. Give me a moment. Let's go to page 26 of 548. At line 13.
I'm sorry, I lost track of the page.
Page 28 of 26 of 548.
Thank you.
At line 13, Mr. Hawkins,
Yes.
you reference the additional protections should similar issues arise in the future. If similar issues arise, won't El Paso Electric again conclude that there was no default?
Don't know what you're asking. So if you, which issue are you talking, should we talk about Buena Vista separately than Hecate or talk about them together?
We could talk about either one.
Okay, so
How do you exactly see that those additional protections exist in the amendments?
well, particularly the increased security amount.
So that increased security amount is sufficient to choose to let the supplier walk away? Is that what you mean?
No, remember this is negotiation, so the counterparty doesn't have to agree to anything that they couldn't agree to. So if it took 4 years to replace a resource because they walk away, those amounts certainly wouldn't cover 4 years over summer period or the replacement resource based on those pricings. Now, I'm throwing a number out, if that number is $60 million and we said we want $60 million security fund, they have the right to push back, and they did. We asked for actually higher numbers in the negotiation, and we settled where we settled.
As of this point, has Hecate avoided any construction event of default as defined in the proposed amendments?
That would be a question you might ask Mr. Behrens.
Mr. Behrens, okay. Is Hecate on track to meet the June 1st, 2024 commercial operations date?
My understanding is based on the agreement that we have with them, I expect them to meet the contracted terms.
That's not what I asked you.
I can only give you, and I'm not on the ground with that project. We have a contract with them with a specified date. I know there is work being done towards that project. So the best I can tell you is I expect them to meet the contractual date.
Is El Paso Electric on track to meet its contractual date according to the PPAs?
So that would be a question for Mr. Davis as far as EPE's obligations in bringing that facility online.
Has El Paso Electric commenced construction of the interconnection facility for Hecate?
And if it saves time, anything related to the work around interconnection, Mr. Davis is probably a better person to ask on that.
Okay. Does El Paso, I'm going back to Buena Vista. Does El Paso Electric think of Buena Vista as a single project?
I believe there are 2 projects. However, the interconnection agreement requires both projects to be complete. So definitely has 2 PPAs, but 2 projects need to both be commercially available under the LGIA to consider it under LGIA terms in commercial operation.
But you're not proposing 2 different PPAs, either for Buena Vista or for Hecate, is that correct?
I think Buena Vista does have, originally had 2 PPAs and has 2 amended PPAs, as does Hecate. And I believe that was a result of different RFPs being conducted and awarded for each project.
Is there a single LGIA for Hecate as well?
I believe there is.
When Next Era came looking for reserve price proposals and negotiated the increase to the Buena Vista contracts, was it your sense that they were looking for a total dollar amount?
I don't know that I thought in those terms, but it, understanding a cost per megawatt hour implies that there is a total dollar impact to everyone involved, customers, NextEra. So I don't remember specifically coming to that conclusion, but that makes sure that's where NextEra was coming from.
Would NextEra have accepted, say, $4.15 per megawatt hour for Buena Vista 1 and left the prices originally negotiated for Buena Vista 2, since those 20 megawatts were already on site?
I don't know. That conversation never took place.
Very well. I think I have no more questions for you, though I do have a number of questions for Mr. Davis. Madam Hearing Examiner, should I ask the remaining questions that I would have asked Mr. Hawkins based on his testimony, but that I'm now expecting he will refer to Mr. Davis? Or can we understand that that would take place?
I would recommend that we ask Mr. Davis all of the questions. Are you talking just about then questions related to the interconnection agreement or agreements?
There were a number of questions that are related to the interconnection facilities, to the construction on the ground, to the current status that's going on with the Hecate projects, with the Buena Vista projects.
I mean, yes, if they're going to be referred to Mr. Davis, then we should ask Mr. Davis, and there's no purpose in asking Mr. Hawkins.
Yeah, and just to be clear, because I don't want to Miss Souls to give up her opportunity. That's correct that Mr. Davis is very familiar with all of the interconnect issues and the LGIA issues. However, he will not be familiar with the PPA issues. So if you have PPA issues, in order to avoid getting Mr. Hawkins up here again, he's the correct witness, except as everyone knows, Mr. Behrens is also talking about the specific provisions of the PPAs.
Then I'm going to ask a couple more questions of Mr. Hawkins, even though I won't be surprised if he refers me to Mr. Davis. We were talking about Hecate and whether or not they have avoided any construction event of default as defined in the proposed amendments. I think that was the question where you referred me to Mr. Davis, but let's start there. Have they avoided a construction event of default?
In terms of default, I think that's the legal question around the agreements. That may be in Mr. Behrens. The actual work and timing of the work, Mr. Davis may have a better understanding of that.
Will Mr. Davis have a sense of whether Hecate is on track to meet the June 1st, 2024 commercial operations date proposed in the amendments?
I believe Mr. Davis wouldn't tell you that he knows what they're doing on the PPA side of the issue. I believe that would be more of a question for Mr. Behrens.
Will Mr. Behrens then know whether or not Hecate submitted an application for the main site use permit to allow the facility to be located on site, and if they did that before November 1st of 2022, as required by the amendment?
I hate to punt to either of them, but that I don't really understand the question enough to know which person you should be asking.
Very well. Of course, the amendment is in your testimony, so very well. Has Hecate provided evidence that all the contracts for the supply of equipment and services necessary to complete construction and installation of the facility have been executed by Hecate as required in the amendments?
You may ask Mr. Behrens that question.
And was Hecate able to execute all of those contracts and still stand by the pricing in the PPA contracts?
They are standing by the pricing of the contracts.
And is El Paso Electric on track to complete the interconnection facility by December 31st, 2023?
That would fall under the Mr. Davis area of expertise as far as interconnection timelines.
Okay. I think that's all of my questions. Thank you very much.
Thank you.
Thank you, Ms. Souls. I guess CCAE, Ms. Lynch, do you have any cross-examination for Mr. Hawkins?
No, ma'am. Thank you, hearing examiner.
Thank you. Mr. Borman, does the utility division have any cross-examination for Mr. Hawkins?
Staff does not have any questions for Mr. Hawkins.
Okay. All right. Well, then I do have a few questions for Mr. Hawkins. And then I think what we'll plan to do is after any redirect, I guess we can see whether there's any requests for recross, but then we'll take a lunch break after that. Hopefully we'll have concluded Mr. Hawkins' testimony. Okay. So Mr. Hawkins, I take it that you were involved in the negotiations over the terms of the amendments on both the Buena Vista and Hecate PPAs?
Yes, I would say primarily with the Buena Vista, just because I was more involved with the actual negotiations, but yes, somewhat with both.
And who else participated in those negotiations for EPE? Let's start with Buena Vista.
Buena Vista, from excluding council, it would have been Victor Martinez as well.
Okay. And how about for Hecate?
Hecate, maybe Mr. Behrens. I know we received proposals through email from Hecate. There was discussions around the original PPA with Hecate that I was involved with, but I think the amendment PPA conversations, Mr. Behrens can give you a better answer on that one. And if he says me, I don't argue with that. I just don't. I may have been party to it. I just don't remember that one specifically.
Okay. Well, so with respect to the negotiations over the amendments on Buena Vista, you had indicated that NextEra did not provide any specific cost data to support their price increase.
That's correct. The first indication of the price increase was around a reservation fee to get in line to secure panels sooner. And to me, it became evident later that it was really about recovering more costs associated with the project, that their costs had gone beyond where they were willing to commit to.
Okay. So there were solar panels on site, correct? And was that for BV Buena Vista 1?
That was for Buena Vista 2.
Okay. And so those panels, was NextEra going to use them for a different project other than Buena Vista 2? Or what was your understanding from NextEra about what was happening with those panels?
So those panels were delivered for the purposes of Buena Vista 2. My understanding, if we did not reach an agreement, a price change to what was originally contracted for, that EP would not have access to any of the panels.
So even though they had been delivered to the site, they belonged to NextEra, and NextEra, did they specifically say we're going to take the panels
Well, no,
away?
no, they didn't. But there's two things to know that under the interconnection agreement, their interconnection agreement was for 120 megawatts of solar panels and a 50 megawatt battery storage facility. They could not choose to solely build the 20 megawatt project. The issue there is that a party could come in with a large project, cause additional transmission costs and upgrades to be done to meet a large project, and then reduce that project after the fact to something smaller. So in this case, both BV1 and BV2 had to come online in order to have an effective interconnection agreement.
And how does that interact with the use of the panels that had been delivered?
Well, under the agreement, El Paso only owns the energy output. We don't own the facilities. So we couldn't lay claim to the actual materials.
Right. And I think that maybe some of the questions earlier, my understanding of them was that what would be the basis for a need to reference the federal investigation if the panels were already there and had already been purchased?
So the federal investigation certainly impacted their ability, or they communicated to EPE that it impacted their ability to secure panels even by this pushed out date of November of 2022.
For BV1.
For BV1, correct. And so, as we discussed with Ms. Souls, it soon became apparent that they were negotiating the price for both projects due to the fact that they were stated that the projects were underwater.
And did EPE ask for documentation or evidence of the cost increases?
At that time, they indicated that the costs weren't known, but that their communications with providers are that was the increase that was necessary to secure EPE's panels.
Has EPE contracted with NextEra in the past to construct projects?
I believe we do have, again, I'm going off memory. I believe we might have some solar projects already that are already producing energy with NextEra. I'd have to check to be sure, but it would certainly be in our RPS documents, the providers of each of the projects, of the existing projects. So it can be referenced there.
But going back to that, so
Did EPE request any kind of verification or documentation of the cost increases that were being presented, or it was just these verbal representations, I guess, that were being made by NextEra?
So we had heard that from other parties. We were in the process of a Texas request for proposals that had solar projects. We had an RFP ongoing in New Mexico for solar projects as well. And what we had noticed in those projects were significant price increases over previous RFPs that we had conducted. So to the extent they said they were underwater on their project, that was certainly verified, and I understand that through the prices that we were seeing from other projects coming in.
Or at least consistent with what you were seeing on the other projects?
Correct.
Okay. So to this point, has EPE received any damages that you're aware of as a result of the changes in or the proposed amendments to the contracts?
No, we have not. As far as I know there was a question of a $42,000 amount earlier. My understanding is that we have not, though.
Okay. All right, I don't have any further questions for Mr. Hawkins at this time, so I'll pass Mr. Hawkins for redirect. Mr. Wexler?
I just have three mostly cleanup questions, Madam Hearing Examiner. And so if I may, Mr. Hawkins, my first question is, you were asked by Mr. Elliott about how EPE justified the costs of the Buena Vista projects. Do you recall that?
Makes sense. Yes, understand.
Do you have, if you could go to El Paso Electric Exhibit 1, page 286. This is Exhibit DCH3. And my purpose for pointing this out is so that you can identify for the hearing examiner what this memo is.
Okay, I'm there.
So what is Exhibit DCH3 at page 286 of EPE Exhibit 1?
That is the analysis that EPE conducted based on the proposed $4.88 per megawatt hour proposal from NextEra.
How was this document used by EPE to evaluate that proposal?
We use this basically to identify what we would consider a break-even cost on the proposal to secure those resources in 2023.
So my next question has to do with EPE Exhibit 2. So if you could go there, and by way of introduction of the question, you were asked a series of questions about bringing just Buena Vista 2 online and why that would be difficult. And again, to point out the place in your testimony, if you look at page 18 of EPE Exhibit 2, and I'm looking specifically at lines 13 through 17. Do you have that before you?
Not yet, sorry.
That's all right.
I'm sorry, what page?
It's on page 18 of EPE Exhibit 2.
Thank you.
Do you have that, Mr. Hawkins?
13.
Still working on it.
Yeah. I'm on 18 of page 114 of Exhibit 2.
And if you look at lines 13 through 17, does this identify some of the challenges that you were discussing on cross-examination with having BV2 go online without BV1?
I apologize. Does not have line numbers on what I'm looking at. on page 18 of,
Fair enough. I'm looking at the paragraph that begins, additionally, BV2 is not a viable project without BV1. Do you see that?
I apologize. I was in exhibit DCH2. I apologize for, let me go to exhibit 2, my rebuttal testimony. That does have page numbers. And I'm sorry, it's page 18
It's page
of
18, correct, yeah.
114. Page 18 of 41.
Correct.
Okay.
And again, I'm just identifying this patch of testimony at lines 13 through 17. And is it correct that this line of testimony goes to that question of why BV2 cannot go online without BV1 also being online?
That's correct. That's the language there in my testimony.
And then one just last quick line of questions. You were asked by Ms. Souls about the amount of the security for Buena Vista projects. Do you recall that?
Yes.
Did EPE conduct analysis about what the amount of security ought to be to prevent the counterparty from walking away?
No, we did not prevent from if they had walked away, what the dollar impact would have been at that point.
How did you arrive at the increased security amount?
I believe we looked at I don't recall off the top of my head how it was a negotiated number. I do recall that. And so ultimately that's where we landed on.
And was the purpose, or what was the purpose of increasing the overall security amount? Why was that an objective of EPE's?
Well, it was if Nextera was going to walk away from the project, they certainly would have walked away at a lower security amount. So the intent was there to increase that amount and to increase, I guess, the consequences of them walking away from the agreement.
And then why did EPE negotiate to have the option of purchasing the project?
The idea there was that if they were going to take the project and not complete it due to whatever reasons, that EPE would be the party that they would negotiate with, and EPE could evaluate whether that project could be completed.
Thank you. Nothing further.
Okay. Thank you very much, Mr. Wexler and Mr. Hawkins. Recross can be permitted, but it will be very brief.
This is Ms. Stevens. I have just a couple of really brief questions.
Go ahead, Ms. Stevens.
Mr. Hawkins, hello again. I thought we were done.
Hello.
So Mr. Wexler just asked you about the analysis in Exhibit DCH3. And I wanted to clarify, did the company do any other cost or numerical dollar analyses for before entering into the agreement regarding the amended agreements regarding Buena Vista or Nextera?
I'm scrolling other than Exhibit DCH3.
Yeah.
I can't recall that Mr. Martinez may be aware if we conducted any other analysis on those.
Would you please refer to Exhibit CLC 7?
Let's see. Okay.
And would you agree that the answer to this question has, well, maybe I should ask Mr. If you're officially deferring this question, I'll ask Mr. Martinez or Mr. Behrens
I
Right.
do know in my direct testimony, I have a table in there showing cost impact to customers. I was really thinking in terms of the negotiation, but that would have been after the fact.
You were negotiating to protect customers, and you, after the fact, you just determined what the cost impact was to customers? Could you explain that to me?
Sure. Obviously, and I think you've seen this in various hearings, including EPE hearings, that the cost of replacement for a like resource would have been significant to customers. And so what we were negotiating was a cost impact that we determined through analysis that was satisfactory to both parties to allow that project to continue, and was the best alternative if NextEra chose to walk away from the project. The cost impact to customers would have been significant.
Now, is El Paso Electric on the hook for any cost in this under either the original agreement or the new amended agreements?
And where you, I'm having trouble understanding on the hook.
I guess it goes back to the ratepayer issue. You're assuming that all the cost changes, all the cost increases for the NextEra agreement, and all the costs incurred by El Paso Electric to secure replacement power for whichever periods may need replacement power, they're all going to be borne by the ratepayers, aren't you?
Well, that's probably a legal question. My understanding is that the impact of this cost increase would be an impact to EPE's customers.
And there were no, from the NextEra perspective, they just had to, is it a fair summary of your testimony that they basically just had to decide whether or not walk, as you call it, abandon the project altogether, or to negotiate something with EPE? Do they have a third option to that?
Objection calls for speculation and also lack of foundation as to what NextEra was thinking or what they considered their options to be.
Can you rephrase your question, Ms. Stevens?
Okay. To your knowledge, you've testified to what your inferences about what NextEra was looking for, and you've testified to your inferences that they would walk away, and I believe you testified to your inference that they were underwater on the project. Do you have any knowledge about what their practical options were should EPE have held the line and not acceded to a significant price increase?
Not specific options, no. I know there's a lot of states with RPS requirements that are increasing, and there's a lot of demand for solar panels given the reduced supply. I suspect they would have bid that into another project or another RFP process somewhere.
Was there an offer on the table or an understanding between the parties that if EPE did not change the price, the project would be available at a later date under the original negotiated price, the way that Hecate was?
No.
Did you ask?
Well, understand that the proposal was for a later date at an increased price. That's what was proposed to EPE.
And you didn't push back on that?
Well,
Objection. That's inconsistent with the testimony of Mr. Hawkins. I think he testified that there was pushback on the price.
Not on the date, though. I'm going to move on to another very practical question here. At the beginning of hearing examiner's cross-examination, she asked you who was present in the negotiations, and you identified Victor Martinez and said excluding counsel. And I'd like you to clarify whether at that point you were treating Mr. Behrens as counsel or whether he just wasn't a party to those negotiations in either way, because I think in 2022 he was still not acting as an attorney.
No, it was EP used external counsel on the contract terms and language.
And the actual negotiation on the price, that portion, were you using Mr. Behrens participating as the Director of Energy Solutions?
No.
Okay. I think that's it. Thank you.
Okay, I realize, Mr. Herman, that I skipped you when we were discussing cross-examination. So did you have any cross-examination for Mr. Hawkins?
No, Madam Examiner, but thank you for checking.
You're welcome. Is there any other redirect for Mr. Hawkins? Okay, hearing none, I will release Mr. Hawkins from his duties as a witness in this proceeding. We will go ahead with a lunch break if we can be back at 1 p.m. And we will start with EPE's second witness. And who will be the second witness, Mr. Wexler?
Mr. Davis is our second witness.
Okay, thank you very much. And I will, as I said, we're going off the record. See everyone at 1 p.m.
Thank you.
Mr. Wexler, is Nextera spelled NEXT cap ERA?
It is.
Thank you very much.
Sure.
I'm ready when you are, Judge, or when the parties get here.
Thank you, Mr. Lee. Think Well, I think we're gonna go ahead and go back on the record in 19-00099 and 00348 UT. We'll be commencing with our next witness this afternoon, Bryn Davis for El Paso Electric. Mr. Lee, could you swear Mr. Davis in?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending shall be the truth, the whole truth, and nothing but the truth. You're on mute, sir.
How about now? I do.
Thank you, sir.
Good afternoon, Mr. Davis.
Mr. Wexler.
Could you please state your name and spell it?
My name is Bryn Davis. That's BRYN. Davis, DAVIS.
What is your position at the company?
I am Senior Director of Asset Management Services. That's pretty much the project group.
Do you have before you what's been previously marked as EPE Exhibit 3?
I do.
This is labeled the direct testimony of Bryn Davis. Was this direct testimony prepared by you or under your direct supervision?
Yes, sir, it was.
Do you have any corrections?
I do not.
Are the answers within the direct testimony true and correct to the best of your knowledge?
Yes, they are.
If you were asked the same questions that are outlined in EPE Exhibit 3 today under oath, would you provide the same answers?
Yes, I would.
Madam Hearing Examiner, I offer EPE Exhibit 3.
Is there any objection? Hearing no objection, EPE Exhibit 3 is admitted.
Mr. Davis, you have before you what's been previously marked as EPE Exhibit 4.
I do.
This is labeled the rebuttal testimony of Bryn Davis. Was this rebuttal testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any corrections to this rebuttal testimony?
I do not.
Is the rebuttal testimony true and correct to the best of your knowledge?
Yes, it is.
And if you were asked the same questions that are posed in the rebuttal testimony, would you provide the same answers under oath?
Yes, I would.
I offer EPE Exhibit 4.
Are there any objections to EPE Exhibit 4? Hearing none, EPE Exhibit 4 is admitted.
With that, Madam Hearing Examiner, we offer Mr. Davis for cross-examination.
Thank you. Office of the Attorney General, Mr. Elliott, do you have any cross-examination for Mr. Davis?
Very little, but I will ask it nonetheless. Good afternoon, Mr. Davis.
Good afternoon, sir.
My name's Gideon Elliott. I'm with the Attorney General's office. You responded to our witness, Ms. Glick's testimony in your rebuttal. And you took issue with her statement concerning the adequacy of oversight. And I'm just looking for the specific page so that I can point to you exactly what I'm referring to. But did you see my questioning this morning?
I was paying attention to most of it, sir.
Okay, so my basic question is really about transparency and reporting. And you know, the question that we're focused on is whether or not EPE should be providing more transparency to the commission. Not necessarily, you know, whether that's through an NDA, but some sort of transparency on the changes that are occurring or the status updates that may be pertinent to the commission, as far as understanding whether price increases are reasonable and justified. And I'm just curious, what are your thoughts on the degree of transparency that EPE provided thus far? Is it adequate, or could more be done?
I believe that the current information is adequate. If it was the desire of the commission to acquire more or more frequent or detailed information, I don't see an issue with that, and it can certainly be done.
Madam Hearing Examiner, may I interrupt for 1 second? I just got a text message from Mary Lee Souls that she's in the waiting room.
Oh, thank you.
I'm sorry, Mr. Davis. I'm sorry, Mr. Elliott.
Oh, no, we need her. She said she had a lot of questions for me.
Well, maybe you'd like to keep her in
The way. All right, thank you. Thank you, Ms. Stevens. Ms. Souls, I'm sorry, I hadn't checked the waiting room and seen that you were in there. Mr. Davis just started his cross-examination. Go ahead, Mr. Davis.
I think you're referring to me. Thank you.
Oh, Mr. Elliott, yeah.
So thank you for that answer, Mr. Davis. I guess to flesh that out some more, what sort of information do you think would be most pertinent to share with the commission? For example, this morning I was asking about changes in specific pricing. You know, that whether EPE had asked, you know, for perhaps like a breakdown of what prices had increased. If there was a rule that required EPE to gather that information, or to at least ask for it prior to agreeing to a pricing change, and that information then had to be shared with the commission, do you think that would be beneficial to the commission and perhaps to EPE in these types of situations?
I'm going to object to this line of question. I'm not sure that Mr. Davis talks about reporting to the commission in his testimony. So my objection is outside the scope.
Mr. Elliott.
To the extent it discussed, the question is focused on oversight, and Mr. Davis oversees projects and his team would have direct knowledge of the type of or pace of change on a construction site. I think it's a reasonable question to ask.
The oversight.
Go ahead, Mr. Wexler.
I apologize. Yeah, I apologize for speaking out of turn. I mean, the oversight that Mr. Davis is talking about is in response to Ms. Glick's testimony that EPE did not pay enough attention to what Buena Vista and Hecate were doing with regard to the interconnection. And that is what Mr. Davis is responding to. It has nothing to do with reporting to the commission. And I'm not sure, we'd have to ask Mr. Davis if he feels like he has the foundation to be able to talk to that issue.
Why don't you go ahead, Mr. Elliott, and ask Mr. Davis about his ability to talk about accountability, I guess, to the commission.
Mr. Davis, what is your ability to speak to the oversight you exercise on behalf of the company, and ability to speak to reporting on perhaps pricing changes and status updates that the commission might find useful?
Well, I would say status updates of construction progress, those kind of activities, I'm certainly well aware of. When you inquire about, for example, the megawatt pricing or the PPA pricing, I don't participate in those activities, and I am probably not well qualified, or better put, I am a spectator to those processes as much as anybody. If we're talking about cost of building a facility or raw material, concrete, whatever, I have awareness on that, but I don't really participate in the, I'll call energy pricing side of the PPA. I'm in the ancillary role to that.
But you play kind of you have a unique insight, because those costs are certainly embedded in perhaps the megawatt hour, right? The ultimate bargain for price.
With what you're referring to, some of those costs are, for example, where you would be going to is, I have no idea how much a solar panel costs. I can tell you more about how much the foundation costs to put it on, or how much a concrete cost potentially, or how the market is for that. But I have zero knowledge of what a solar panel costs now or before.
Well, I certainly think that concrete pricing can be almost as important. Do you have insight into labor costs?
In the context of construction, yes. I see those activities all the time, both internally in these projects and across the board. So we do look at that and track those things. And so, yeah, I have awareness of that.
So in terms of providing transparency and reporting on its oversight of PPA projects in the future, what sort of information do you think the commission might find most useful in terms of monitoring pricing inputs?
I would say in pricing inputs, and again, the specific components associated with a solar facility, panels and all, the balance of that, construction costs are pretty universal, whether it's the LGIA, where I spend most of my time, or the facility construction of PPA. We watch that market, and in these cases, there are numbers that float around that most of those things have gone up 30%, 20%, depending on what that is. When we start talking about things on the LGIA side, which might involve cable, conductor, switchgear, or whatever, we're well aware of those costs, both in cost and lead time. I think they're consistent across the industry, and it would probably be worth your while, but I wouldn't judge for the commission how deep you would want to go into that.
Okay, thank you very much for your answers. That That was very helpful. Do you think EPE would be willing to work with the commission on developing a framework for sharing information that doesn't go too deep, but deep enough to provide sort of useful information in a timely fashion?
I can't imagine why we wouldn't be.
Thanks. Appreciate your time and your answers. Thank you.
Thank you, sir.
City of Las Cruces, Ms. Stevens, do you have cross-examination for Mr. Davis?
I do. Thank you. Good afternoon, Mr. Davis. How are you?
I am doing well, and yourself?
I'm doing okay, except I just had a coughing attack. So if I have to run out of here, it's because I'm dying. But we'll do our best. So as you were noticed this morning, Mr. Hawkins deferred a lot of questions to you. So I'm going to ask you some questions similar to those that I asked Mr. Hawkins about the status of the Buena Vista Hecate projects. And am I correct in understanding that your knowledge is primarily from the perspective of the interconnection facilities and the LGIAs?
That would be correct. And we have some visibility into the other side simply because as the facilities get commissioned, they're closely tied as they become energized.
Do you receive the reports from the reports, the monthly or quarterly reports on progress from the developers? Are you on the circulation list?
With regard to the PPA?
With regard to the PPA?
I am not on that distribution list.
And have you seen some of those reports in the course of working in this case?
I believe I've probably seen a few over time, and that may be simply because someone may ask me for some technical input.
Okay, that's helpful. I will be asking you about the ones that's attached to Mr. Hawkins's rebuttal testimony, which apparently is the most recent one. So, according to your direct testimony, the protection and control or work on the Otero substation was completed by the time you filed your testimony on November 14th, 2022, wasn't it?
Yes.
And according to your testimony also at that time, none of the generating facilities were not operational or generating any output?
I cannot speak to the operational side. I can only presume, but they were not generating any output at that point.
Okay. And on page 8 of your direct testimony, you described the next step after the PRC work as commissioning, which includes the flow of test power. Again, what you were listening to Mr. Hawkins this morning.
I'm going to that. Are we page 8 of 12? Is that what you're asking? Or
I'm on page 6 to 7 of your page 8 of your 8. No, on the Bates numbers. But when you say that commissioning includes the flow of test power, so do you agree with Mr. Hawkins that some testing has commenced on the Buena Vista facilities?
Yes, I do.
And do you agree that the 20 megawatts is producing energy on a somewhat regular basis?
I would agree with that, but I would clarify that it's not 20 megawatts. They are generating power of the installed 20 megawatts. I don't think there is a number that could be 1 megawatt, that could be 15. It is not an on and off kind of an activity. As they commission, they flow power to check their systems.
So they're just doing checking? Is any of it going through the point of interconnection and into the EPE system?
Yes, it is. It is referred to as test energy. If they are generating power and testing their facilities, it has to go somewhere, and we're it.
Do you, that seems obvious. Do they tell you in advance when they're testing how much they expect is going to the system, or do they just tell you they're going to have a test today?
So the normal process, and just because of the test energy, I'm sort of on the edge of this. So I have seen some of these, but typically when they're commissioning, they provide our system operations with a schedule of what their intention is for testing, which includes what time of the day and the potential amount of energy they intend to flow into the system. And they provide a schedule to our system operations people so we can account for it.
In
And
a
that,
situation,
that schedule changes as their testing evolves.
you mean within the day or over time?
More over time. And I would say if they have a problem or they discover something, they may stop flowing power so that they diagnose, and then they will issue a new intended schedule for testing.
And is this situation with the Buena Vista facility with a 20 megawatt facility and a 100 megawatt facility, is that a unique situation for your transmission related department to deal with?
So let me rephrase that a little bit. I think I'll answer your question. That is from our side, and when I'm talking about that, the EPE side of receiving that energy, I really have, I would say, I have no knowledge where it comes from, just how it comes through the point of interconnection in the process. And the reason we generally want to know that is to make sure that we can operate our system safely and effectively. So we're just wanting to know what we should be expecting to see. I at the point of interconnection again, where that power comes in, I really wouldn't be able to discern without them telling me whether it came from 80 panels, one panel, a battery system. It just shows up over the wire for me.
When they do the schedule, I'm glad you mentioned the battery system. When they do the scheduling, are they informing you that they're testing the battery or that some of the power may be coming out of the battery system? Or again, is that just not relevant from your side?
They may be informing our folks in the operations side. I am unaware of that activity, the source.
Are you, again, I don't know exactly your role with this specific project. Are you aware of the actual like day-to-day activities still? I know that when they were built, when the interconnection facilities were being built, you were more closely involved.
So I'm aware of the Otero substation activities as that is fully operational and in our system. I am less aware of the nuances of the Buena Vista generating facility.
Would you turn to Mr. Hawkins's rebuttal testimony, EP Exhibit 2, please?
It'd take me a second to get there.
Yeah. I'm going to make it easy by asking you to go to the back of the die.
Is this City of Las Cruces exhibit 2, or are we looking?
No, it's EPE Exhibit 02 rebuttal testimony, David C. Hawkins.
All right, I'm getting there. Okay, I've got it. The 42-page document open.
Right. So we're going to pull you towards the end on page 33 of 42, which is actually labeled 41 at the bottom, but it's 42.
Okay. I'm with you. I'm on the PDF page numbers.
Right. Okay. So this is identified as a progress report from Next Era to Daniel Freer at EPE. Have you seen this report before?
I'm looking at it. I can't say that I've seen the report, but I am as I read through here, I am somewhat aware of the content.
Okay, good. Let's go to the second page of that, page 34 of 42 in the PDF.
Okay.
And I'm under in the paragraphs that follow the heading panel status and construction.
Okay.
You just mentioned earlier about the 20 megawatts being operational. This refers to the remaining 43 megawatts that were detained. Does that mean that there's well over 20 megawatts of capacity now available at the Buena Vista site?
Now as in today?
That was in today, yeah.
I don't know if they have 100% of their panels installed online, but I am pretty confident that they have the bulk, if not all the panels installed at this point.
And have they been making requests in recent days or weeks to do tests at levels, tests at levels higher than 20 megawatts?
I am unaware of that right now. I don't know the level they're testing. That those communications, as we orchestrate these activities, start becoming directly between our system operations folks and the Buena Vista people. The connection facility can handle 0 to 100% of the power. So I'm not engaged on that as much, if that makes sense.
Oh, I understand. 100%, let me clarify, 100% is 120 megawatts, is that right?
Yes.
And given your role, would you be advised if there was some sort of a problem? Or are you really kind of, as it has gone past you?
Most of that's gone past me. From a standpoint of the LGIA, once they have delivered the power, the full power that's identified in the LGIA, I will become sort of notified that those things have happened as we start trying to close out the LGIA document. In the LGIA, what it basically refers to is once they've done commission and test power, the aggregate power of the LGIA, which means everything. Once they've flowed that, then we can start closing out the LGIA.
And Mr. Davis, you said that you were listening to Mr. Hawkins's testimony. I asked him about the company's standard LGIA, and that's section 5.9 that provides for partial interconnections. Was the LGIA negotiated with NextEra or Buena Vista Energy Center, a non-standard agreement?
So the LGIA, when the LGIA, I'm not part of the negotiation. When the LGIA is executed, it gets turned over to the project side, to my team, and then we go build it. But I am aware that it is a non-standard LGIA. In particular, the reason for that is our LGIAs do some things called cluster studies, which means they group some activities together. But I know it's a non-standard LGIA, but I'm familiar with the LGIA document. Your question on this is these alternative power flows or whatever.
Yeah. So if you were, so I think what you just told me is that somebody else negotiated the LGIA and then you've been given it to supervise, execute, whatever you want to call it, from this company's side. And so you would be aware of the fact that the terms, and if the terms concerning partial connections had been modified from the standard, would you be?
Absolutely, because our interconnection side, if they amend the interconnection agreement, they certainly have to let my team know so that we are operating or pursuing against the proper documentation.
And when next year in December of 2022 asked for an accelerated COD of December 31st, 2022 for the 20 megawatts. Was that brought to your attention, or were you asked to resolve that, say yes, no, maybe?
It wasn't brought outright to my attention. The interconnection, the LGIA, the facility was capable of handling at that point the full capacity of what is defined in the LGIA. If they wish to provide less than that, my answer would simply be, that's not a problem.
Okay. And the same would be true when they push that date back to February 28th, 2023. Not a problem from your perspective?
Once the Otero substation has been energized and operational, it is capable of accepting the full power that could be put into the system. So once we were online, we're still online, even today.
And it's also capable of taking less than the full 120 megawatts. Right? And this is really probably unfair to you, but I'm going to ask anyway because you're the one. In the same paragraph here on this report, and I'm on page 34 of 42, Mr. Hawkins' rebuttal testimony. The last paragraph there starts with, it has been conveyed by both EPE and Buena Vista teams that the Otero switchyard was energized and, emphasized, synchronized prior to the transfer of ownership of the switchyard to EPE. This triggered a FERC 203 issue, et cetera, et cetera. Are you part of the EPE team that conveyed this issue, that identified and conveyed this issue?
Conveyed to who, ma'am?
I'm not sure because this is written in the passive tense.
Well,
Were you part of the team that identified an issue?
I am aware. Our regulatory attorneys identified this as well. We are in a joint operating agreement right now. The Otero switchyard has not been transferred in ownership, but we are operating it under what's referred to here as a operations agreement.
And that happened. This says that it was in a draft form and would be delivered to EPA by February 1st, 2023. Is that operating agreement now in effect?
There is an interim operating agreement that has been in effect since we started the facility, and the I'll call final version of that operation agreement. I don't know if that has been completed. It is just the document that allows us to run the facility and do so until the facility transfers ownership to us.
When is it anticipated that ownership will transfer to you?
I don't know, ma'am. I don't know that a date's been set. We are dependent on the NextEra people for part of that activity. There are financial and documentation criteria associated with that in order for the transfer to happen.
Are those criteria derived from the LGIA or the PPA or PPAs in the plural, or both?
I would surmise, and I'm not an attorney, but I would surmise this is all conditions of the LGIA, because the Otero switchyard is exclusively in the LGIA.
Okay. I think that covers. Oh, I do have one last question about next year, and then we'll move on to a quick checkup on the state of Hecate. And this is on page 12 of your own testimony.
My direct?
Your rebuttal, I think it was. Let me see. Give me a second here. I'm sorry for being discombobulated. I have all these notes to Mr. Your rebuttal testimony, page 11, page 12, I mean. It's actually page 9 to 10. It's page 11 to 12 of the PDF. That bottom paragraph on page 11.
Okay, I believe this is distinguishing between the PPA and the LGIA is the
Right.
conversation.
Good. So, so I think you're saying here, I think you're giving the opinion that based on what you just said, that so the LGIA has a condition for completion that is it the LGIA? The LGIA requires the flow of test power at the aggregate capacity.
That's correct.
And the PPA won't be happy until the LGA is fully fulfilled. Is that what this means?
I cannot answer on the PPA, all the conditions on the PPA. On the LGIA, and that term aggregate is important, is the LGIA, in order to be COD and complete on the LGIA, the power must flow at the aggregate capacity of the generation identified in the LGIA. So in that case where there's 100 megawatts and 20 megawatts, all that has to be aggregate flow at the same time in order for the LGIA to be complete, the test power.
And it doesn't matter whether it's coming out of the battery or out of the generators, as long as 120 goes through your point of interconnection, right?
That is correct.
Now, moving on to the next page, 12 of 16, this phrase, delivering it to the POI on time and on schedule. What does on time and on schedule mean? What is the process there that triggers this on time and on schedule? What does that mean in that sentence?
So on time and on schedule for the LGIA and the PPA obviously are intertwined. They're two sides of the same coin. If the generating facilities that are defined in the PPA are not capable of generating the power, then the LGIA will not be satisfied until such time as the generating facility can provide the power. Does that make sense?
Yeah, I'm just asking a kind of a narrower question. Just technically, what did you mean by saying delivering it to the POI, quote, on time and on schedule? What does on time and on schedule mean? What time, what schedule, I guess?
So the LGIA, the on time and on schedule is the PPA, the generating facilities on their time and schedule. They have to be complete in order to do that. The LGIA will fundamentally, in this case, wait until the PPAs are fulfilled.
Okay, let's move on to the Hecate project, which we know is not quite that close. Let's look at your direct testimony, please. And my notes say page 7 to 8. Let's hope that I was using the PDF, but not the. I'm afraid it's probably pages 9 to, oh, maybe to 70. It's pages 9 to 10. We're talking about the Hecate project. So, as it was your direct testimony was written in mid-November, right?
Correct.
And as of that time, Hecate had posted approximately 12 million of security.
I believe that is correct. That should be what my testimony said. It was right about $12 million. That is on page 9.
9.
of-
And on the same page, you say that as of October 2022, slightly under 2 million has been expended. Has that changed since October?
I am sure it has. We have been working in support of the Hecate project. I don't think I could give you a dollar value, but we have been expending resources continually in preparation for this effort.
Are those expenditures still in terms of design and planning and permitting, or are you actually doing any breaking ground?
Oh, you're stealing the thunder from Miss Souls.
I'm
we
sure
have-
she'll come in with much more detail, but
We have not.
warm up.
Okay, we have not yet broken ground. We have been in design activities, what we call system planning studies, which size components and equipment. And we are slated in the current schedule to deploy and break ground in April.
Okay, and that was going to be my next question, because on the top of page 10 in your direct, you say slated to start in December 2022, and now you're saying April 2023. That's, let me count on my fingers. That's a 4-month delay.
The schedule has changed with our project people at least twice since this testimony was prepared.
Oh,
And it's been negotiated back and forth. We have what is called an EPC, an engineering procure construct contract associated with this. In simple terms, for me, I am as much interested in the end date as I am in the start date. And so we look at that side. The contractor had requested to delay their deployment once and had indicated they might try and delay a little longer, both on weather and resources. And for us, El Paso Electric, if they're meeting the other end of the timeline, I have no objection.
Given what happened with Buena Vista interconnection facilities, how do you assure that they're going to meet a timeline before the spring season when it becomes more difficult? You know, what level, what cushion are you putting in there?
So that's a multiple area question. The Buena Vista facilities, in order for them to come online, had to intercept multiple transmission lines in a section of our system that has more limits than where this particular system is going in. So the ability to intercept the transmission line where the Hecate people are going, what's called Verde substation, is an easier activity for us in terms of being able to access the system. We are not cutting anybody off, as it were, like we had to, which dictates our outage. And when I say our outage, the outage is not just us. Our peer utilities have to agree to that. So in this case, that is less of a concern. And again, maybe going back to other thunder, we've actually had several conversations with our EPC contractor about the market issues that were determined on the control cables to make sure that they are ordering them well in advance. So we certainly have lessons learned that we relay to ensure our interests are being met.
And with this project, is there going to be a period of a transmission outage at all?
There will be a transmission outage to intercept what is currently the Diablo to Santa Teresa substation line.
I'm sorry, sir. What is currently the obload?
What is the current transmission line is from the Diablo substation to the Santa Teresa substation. And we will be intercepting that line. I know we have outage requests in our system to do that. I don't believe at this point we are seeing any issues in terms of timing.
First, is given the nature of this one, is it going to be a shorter outage than the one that was required for the 345 station for Buena Vista?
I would expect that it would be similar in the process. The P&C work, which we reserve for our people to do simply for safety and operation system, is typically allotted for 12 weeks. And there is an outage period that is anywhere from 4 to 8 weeks. Typically, if we're well prepared, 4 weeks, we would make the same request. That would include the physical interception of the line and the reconfiguration of the protection and control systems.
So in order to accomplish this and get Hecate online in June of 2024, will you be looking at roughly the same time frame that you'll need to have, that you'll need the 12 weeks in the spring, late winter, spring of 2024? Is it tracking from a calendar standpoint? Is it sort of tracking the Buena Vista system situation?
I don't look at those as tracking each other, ma'am. I would tell you, we intend to be substantially complete by the end of this year, by January 1, and there is some commissioning work that will go on to about February. The question you have is on the Buena Vista is we basically cannot access the system in the what we call the peak period in the summer when loads are high. This work is already going to occur in the non-peak period of the season. So we're actually very well positioned to accomplish this work.
And you did testify though that you need other utilities to consent your schedule.
On the other side, yes, I don't know that this will impact anybody else but us in this particular location.
So on the other side, you're talking about Hecate, or are you back to Buena Vista?
Hecate won't impact anybody else.
Okay. But you will still want the 12 weeks P&C time, including a 4 to 8 week outage.
Yes.
And you'll want that in the winter months, winter to spring months.
We intend to do it in the late fall this year.
Okay. And given that you haven't broken ground, how do we know that, what assurances do we have that the work will be substantially complete, as you just said, by January 1st, 2024?
Well, first, I smile because my people are doing it. This is not a self-build option by someone else. This is being built by EPE through contracted resources. We certainly have more control over the process, and frankly, I have every confidence in my people.
Okay, one quick question here about the work that you did do on the site with regard to Buena Vista in 2021 and 2022. Would you please turn to CLC exhibit number 18?
Make me get my glasses again. Okay, I have it up.
And do you recognize this as a list of site visits to the Otero substation?
I do.
And I see that you show up on a few of those visits. I'm looking at page 2 of 3. and on March 25th, 2022.
Okay,
It looks like a lot of people made a site visit to the Otero substation. Was that all one visit, or were that 10 people or so for this company all there at the same time, or were those just sequential visits?
so I'm kind of going up the list, and I believe it starts with Rochelle Williams, and then it ends possibly, I may be the last one on the list. Luke Cisco, James Sundell. This was a visit with a select group of, I will say, not directly involved folks in El Paso Electric. If you look at the titles of some of those people, treasurer, financial officer, information technology, from time to time, we bring in other parts of the company as part of a diligence to make sure that they have hands-on understanding of what is going on, I'll call in the field, and what things are happening. It is often very tough to appreciate the scope and scale of these projects by doing so from your desk or reading a report. So on a regular basis, we will try and get people out into the field when it is convenient. And I believe I believe in one of our other responses to the city there, we actually visited several facilities on this trip to look at different construction projects. I believe we went to our Newman generation. We went to a couple other places. So this is both an opportunity for me to go keep track in and see how things are going, as well as I'm going to use the word enlighten or provide exposure to folks in the company who don't regularly see it.
And by March 25th, 2022, you knew that there was a problem. You knew that the problems with the communications cable were impeding EPE or NextEra from getting the project online in May of 2022, correct?
So the window of opportunity had passed to do the protection and control work,
Right.
which meant we would have to wait until the fall, which is what we did.
And that was that an issue during that site visit? Or a topic of discussion?
It was a topic. It was a status of construction, so it was a topic.
I'd like to ask you to look at Ms. LaRock's direct testimony on behalf of the city, CLC Exhibit number 1.
One moment. So I have Exhibit 1, direct testimony of Lisa LaRock.
Okay, now I thought I had a note here. Where in her testimony? Yeah, okay. Were you consulted during the discovery process in this case, Mr. Davis, other than to?
I don't understand your question.
Were you consulted about the discovery that was produced by the company to the city and whether or not certain things should be confidential?
No, that's not in my purview, whether it's confidential or not.
Okay. Would you accept that the company took the position that a lot of emails were confidential, so we weren't able to attach all of the correspondence that they shared with us in full in the appearance of the email messages because there was an agreement between parties?
Well, as it was out of my purview, certainly I can accept that. I don't have input into that.
Yeah, I'm asking, would you turn to page 42 of 154 of Ms. LaRock's testimony? And you did read Ms. LaRock's testimony because you rebutted it, right?
Yes, I've read it.
Okay, and you didn't take issue with her description of this correspondence, this summarized correspondence that she quoted in her testimony on page 42 of 154, correct?
I did not.
Okay, so direct you to line 17 on that page, 42 of 154. And
I'm there.
okay, and at that time, this was March 24th, 2022. It was your observation. I'm looking at that parenthetical, that there are no panels yet. Is that your observation on that site visit?
That is my observation.
I think that is all I have for you. Thank you very much, Mr. Davis. A light warm up before Miss Soul gets to be here. It's good to see you again.
Good to see you.
Thank you.
Miss Souls, cross-examination of Mr. Davis.
Hello, Mr. Davis.
Hello.
Sounded like you did need that warm up. I have some questions to follow up with what Ms. Stevens was asking you. You said something about the Buena Vista LGIA being related to a cluster study. What does that mean?
So the way, and I can't speak for all utilities, but in many of El Paso Electric's interconnections, we may have multiple parties who are trying to do an interconnection process in a simultaneous time frame, which for us then implies that we may have multiple activities we have to do related to each of the interconnections, and some that may be held common to both. In your question to Mr. Hawkins, which I think he deferred to, you asked about network upgrades. A lot of times when there's a cluster, there may be upgrades across the system necessary to accommodate one or both of the interconnectors.
There is another interconnector then?
There was a interconnection application at the time that the studies were done.
And who was that, or what was it for?
I would have to go look at the LGIA to be able to identify that. I can surmise that it was a connection over on the west side of El Paso, and I only say that from the knowledge that the network upgrades identified some work at Diablo substation, which is far from the Buena Vista facility. But I could not tell you at the top of my head who that was.
So was that a required network upgrade?
The interconnection identifies the upgrades that are necessary in order to accommodate the flow of power from the interconnector, and we pursue those. In this case for Buena Vista, that involved communications. It involved protection and control at the adjacent substations to the newly installed Otero substation. And I think there might have been a transmission capacity upgrade as well that was identified in there.
Have those upgrades been completed?
Yes.
And when was that?
They were complete by the time we energized the Otero substation. If you need an exact date, I would have to go look that up, but they were well and complete by the time we energized the substation.
When did you energize the substation?
It was energized, I believe we were capable at the December, January window, 2022, 2023.
So within the last 3 months?
At the beginning of the year.
Okay. And so the completion of those upgrades that we were talking about, they occurred, what, a month before that?
Ma'am, without going and look, I couldn't answer. I would surmise that most of those things were done almost a year before that. And the reason I say that is we were anticipating being able to do the protection and control work before the window of opportunity passed. Our crews would have been working to make sure that everything else was ready in that window.
And you don't know for certain when they would have actually been completed.
That is not at my I'll call it my fingertips or the tip of my mind right now.
Okay. So if you were anticipating that Buena Vista was going to commence, be energized in time to do PNC work last year before the summer season, why wasn't there enough time to deal with all of the delays that have been occurring with the Buena Vista system since it has been energized?
I don't believe I understand your question. Are you talking about the generating facility?
So it's my understanding from the various pieces of testimony that even though everything's in place, there are still barriers to commencing commercial operation, to making this not in a construction phase, but in an operations phase. Would you agree with that?
I would agree that the generating facility is working through their commissioning process in order to be able to deliver all the power they intend to deliver. The Otero substation is completely commissioned and operating, so it is functional and able to receive.
So the Otero substation, then the FERC issue is completely put to bed. Is that correct?
I did not say that. I said it's able to receive power. The FERC issue will not be resolved until the complete transfer of ownership occurs. But we, El Paso Electric, are operating the facility under agreement right now.
I recall something about standard operating procedures that hadn't been written. Is that complete?
We have operating procedures for the substation.
And were they available like a year ago or within the last month or two?
They were developed once we commenced operating the substation.
Then my question is really, why weren't they developed prior to operating the substation?
I would say that they were probably they were in a draft form. The pieces of information to finalize those procedures are dependent on technical knowledge of the equipment and configuration, and we would not finalize those until we would take over the facility to operate.
Okay.
And for us, you kind of asked about that commissioning. The other part of that is that doesn't include what the Buena Vista generating facility may be doing.
Very well. So I'm not sure how much of this Ms. Stevens has already covered. So this may be a little rocky. If you'll bear with me, let's go to your direct testimony at page 4 of 12. Now we've done that. Let's go to page 6 of 12.
Okay.
And at line 10, I think we talked about the upgrades that you reference here. Is there any other upgrades that were related to this?
The upgrades are defined in the LGIA, and I think we touched base. There is protection and control work that affects both the adjoining facilities. There was communication, and then in this particular case, we also had to relocate 2 transmission lines essentially around the site in order to make things work. And all those are done.
And whose responsibility was it to relocate the transmission lines?
El Paso Electric.
And when was that completed?
That was completed almost at the onset of construction of the substation, very early in the process.
Okay. The testing, what's the status of the testing with the facilities?
The testing is complete. The facilities are tested and commissioned and are operating.
So all of that you're referencing there in your testimony is behind us at this point. Is that correct?
That is correct.
Okay. The interconnection facilities, all of those have been energized at this point. Is that correct?
Yes, and I'll clarify, when you say that, that is what we refer to as the transmission providers interconnection facilities, that being everything on the El Paso Electric side of that point of interconnection. As you have noted, the PPA and the LGIA are different, and they tend to overlap terms.
Yes, they do. And so that interconnection work that was El Paso Electric's responsibility, when was that completed?
The parts of El Paso, they were completed approximately in November this past year. That was the final commissioning of the protection and control work.
Okay. Let's talk about Hecate. You
Okay.
established with Ms. Stevens that Hecate that El Paso Electric is responsible for building that interconnection. Is that correct?
That's correct. In Buena Vista, they elected to self-build. In the case of Hecate, they did not select that choice. So El Paso Electric is responsible for building the transmission providers interconnection facilities.
Okay. If you would go to page 10 of 12.
Okay, in the direct testimony, I'm there.
I think, yes, I believe I'm still on the direct testimony. At line 3, site construction activities are currently slated to start in December of 2022. This is what you discussed with Ms. Stevens, that it's now April of 2023. Is that correct?
That is correct.
And am I also correct that prior to October 3rd of 2022, the COD for Hecate was May of 2023?
I'll have to take your word. I believe that's correct, but I believe that was the COD at that time.
So prior to the proposed amendments, and wouldn't you have had to commence construction of the interconnection facility like by a year ago in order to meet that COD?
Yes, ma'am.
So why haven't you already commenced the construction of the interconnection facility?
So there are a couple things that have driven that. One is there are pieces of information associated with the generator Hecate that we need in order to size and design breakers and protection and control systems to have the right equipment to be compatible to their process. That has been a fluid activity on their side of the activity. So we did a preliminary study, we did a second study, and then in addition, there was a point here where there are 2 PPAs associated with the Hecate folks. And at one point, they actually had 2 points of interconnection that they've consolidated to 1. So we deferred our activities pending getting the information from them to start. As I noted to Ms. Stevens, the end point is more important to me than the start point. Our EPC contractor is estimating, and we have a lot of experience with them. They and their sister entities, our key supplier, El Paso Electric, have slated an approximate 9-month schedule to be substantially complete. So we've been looking at their activities and their lead time and their procurement processes to make sure they can get there. And we still have every confidence in their timing.
So I thought I read in the proposed amendments for the Hecate PPAs, I know that's not yours, but for the Hecate PPAs, that Hecate was to have put out all of the contracts for the required material no later than the end of the year 2022, that was a construction milestone. Has that happened?
I don't know. I'm not on the PPA side. Those are milestones for them to build their facility. I operate under the assumption that they will meet their contractual obligations and be complete when they say they're going to be complete. And my project folks we will be ready on our side of the point of interconnection well in advance of their advertised schedule.
So, but you weren't able to say that regarding the previous COD milestone prior to these amendments because El Paso Electric hadn't commenced, hadn't finished, hadn't done what they needed to do regarding the LGIA interconnection facility. So is this, you wait for them and they wait for you?
We're engaged in regular conversations with the Hecate people. We're engaged in the LGIA. There are conversations of schedule and timing that go on in a regular basis. And so it's not a back and forth as simple as this may sound. My team, our goal is to beat the date and be ready whether the other side of the POI is ready or not. And in this case, our target is to be substantially complete at the end of this calendar year and ready to be energized in February. The Hecate people are currently specifying an energization date of, I believe it's peak or May of 2024. And we intend to be ready and able to receive power well before that.
What happens if you're not?
There are penalties both ways. You would have to ask our legal folks. I would defer to Matt in that process, Matt Behrens, that there are conditions on both sides of that for I'll call it default or not delivering. And I'll add, we'll be there.
I want to believe you. So would it be accurate to reflect this as El Paso Electric was not the reason that the Hecate COD dates have had to be postponed to 2024?
Absolutely.
Okay, thank you. Let's go to your rebuttal testimony, please. At page 5 of 15.
Hang on, I got a few too many things open here. I may have actually closed that. Let me find, because okay, I think I'm at the right.
So first, let me see if this is going to be useful. Regarding the control cable that was not available at approximately this time last year, is that related to the interconnection facility?
Yes,
Okay.
we are now on Buena Vista again.
We're on Buena Vista again. Yes, sir. Because we had to go to your rebuttal. Yes, we are. And am I correct that El Paso Electric reviewed the design and the material required for the Otero substation construction?
Yes, as part of our, I'll call oversight and monitoring, we have been engaged with these guys, their construction, their engineering teams from day one in the process. We provide standards, we review their designs, we provide commentary, because even though it is, they have elected to self-build, ultimately they're building a facility that has to meet our specs, our requirements, and will, as we've talked before, ultimately be handed over to us as the owners.
And I think I read someplace that El Paso Electric actually approves the design and the material list. Is that true?
That is correct. We approve the design and we approve the material list from a specification standpoint.
Was this missing control cable on that list of material that was required?
Yes.
Was all of that completed on time according to the project timetable?
The review and approval?
Yes.
Yes, it was.
And then would you have overseen whether or not NextEra ordered the material that was on that list?
I would say that when we are monitoring the project, we are talking to them about delivery schedules of material and when they expect to do it and what their timelines are. If you're asking me, did I see a copy of the purchase orders or when they place the orders? We didn't see that, but we knew their timelines and it was a topic of conversation.
Okay. And when were you aware that the control cable was going to be a problem?
As a problem, we became aware of that in January of last year, and particularly when it became a problem is when it was apparent that it was not getting delivered as it was promised by the suppliers to the Buena Vista people.
Do I understand you then that it was the conclusion that the supplier was failing to deliver, not that the material had been failed to be ordered?
You are understanding correctly.
Thank you. How long? I'm going to talk about Hecate now. I'm sorry about the back and forth.
It's okay.
How long do you have in the plan for the protection and control activities related to the Hecate facilities?
So
The Hecate,
Facilities, Hecate facilities, sorry.
So in the EPC contract where we are building the substation, Verde substation, We have specifically brought to our EPC contractor the lead time issues that were discovered or lessons learned in the Buena Vista activity. And so they are paying both extra attention in lead time and delivery times for those materials. I can't definitively answer, but I would not be surprised if they're not already on order now, as long lead items are being procured already for this substation.
And when do you plan to conduct the protection and control activities?
Those activities always happen at the tail end of the construction activities. They are one of the final activities associated with completing and commissioning the substation.
Does that mean that you intend to have it completed before the end of December of 2023?
Yes.
And how long have you planned for that?
It's been in the construction schedule. The P&C activities are part of the construction schedule. So they have been in all of our construction schedules with the EPC contractor.
So what I'm trying to get at, Mr. Davis, I've heard in various different communications, 6 weeks, 8 weeks, 10 weeks, 12 weeks. What is this that you're planning for?
So when we initially do, we almost always allot 12 weeks for the P&C activities. We allot, depending on what's going on, we allot usually anywhere between 8 and 4 weeks for the outage activity. In the case where I think you're going, in the case of Buena Vista, since there was such a delay of being able to have the outage, we actually were able to make up a little bit of time in some of our work that would normally overlap in the outage activity. But we normally allot between 4 and 8 weeks to do that for our convenience.
Very well. On page 9 of 15, okay, at line 18.
Hang on a second. I inadvertently clicked on the X. I got to go open me back up in my rebuttal. Okay, I'm there.
All right. You're discussing El Paso Electric's obligations as the transmission provider under the LGIA. Did El Paso Electric fulfill all of its obligations under the Buena Vista LGIA on time?
Yes.
I'm so happy with that answer. All right, now I'm back to Hecate and things that I believe Mr. Hawkins sent to you. I asked him if Hecate has avoided any construction event of default as defined in the proposed amendments.
This is the PPA amendment?
Yes, sir, I'm afraid so.
Okay, I have very limited knowledge of the PPA amendment.
The one I'm most interested in, it had a December 31st, 2022 date for Hecate to order all of the materials. Do you know if Hecate has done that?
I have no idea whether they have ordered those materials or not.
Okay. Mr. Davis, I think those are all of my questions. I appreciate your testimony. Thank you.
But thank you.
Thank you, Ms. Souls. CCAE, Ms. Lynch, do you have any cross-examination for Mr. Davis?
Hearing examiner, I do not. Thank you for asking.
Doña Ana County, Mr. Herman, do you have any cross-examination for Mr. Davis?
I do. Let me just check. Am I coming in okay, or should I switch to my microphone?
Fine for me.
Mr. Lee?
It's good so far, but it could get rocky. You sound a little distant.
I get a little echo in here. I'm just going to switch to my headphones if you give me a minute. Okay. Good afternoon, Mr. Davis.
Good afternoon, sir.
My name is Keith Herman. I'm an attorney on behalf of Doña Ana County. And I had a couple questions for you. If you could refer to your direct testimony. Starting at page 5 of 12, where you're discussing the FERC interconnection procedures.
Okay, the large generator interconnection procedures.
Yes, you're discussing that at the question starting at page 5 of 12 with relation to Buena Vista and with respect to Hecate at page 9 of 12, starting at line 4, correct?
I'm going down there to see. Okay, I agree with that.
So specifically going back to page 5 of 12, you state that FERC's interconnection procedures require the generator to initially fund the engineering construction work necessary for the interconnection, correct?
That is correct.
So maybe for my own edification, you can tell me what happens to or how is that money recovered by the generator in these instances?
So the LGIA process, when those activities are funded, and including the whether the construction, whether it is self-built by them or built by El Paso Electric, obviously both have some cost. Those funds, those costs are repaid back to the generator and can happen in a variety of ways. El Paso Electric, and I am not the one to make those choices, but we could pay them back in the entirety at COD. We can pay them back over time. The typical way, in my experience, is these things are paid over time, and essentially what happens is, as power is generated and delivered to El Paso Electric, or we're carrying power, there are dollars associated with that. And those things, rather than being paid for, are credited against the cost of the facilities until they're made whole. Does that make sense?
Yeah, and just to clarify, I'm pretty sure in both these instances, the generators opted to self-build, correct?
That is incorrect, sir. Buena Vista elected to self-build the interconnection facilities. That's the part that's EPE, not their generating facilities, but the EPE transmission providers interconnection facilities. In the case of Hecate, they did not elect that, and El Paso Electric is building the transmission providers interconnection facilities.
Okay, thank you for that clarification. Do you know what the estimated cost of that interconnection is associated with Buena Vista that they are self-building?
So the original cost estimate, and this is back in the original interconnection days, I believe was on the order of $14 million. The current cost, where we're currently reviewing their activities, that number is approximately $18 million in total. We are reviewing, I'll call it their invoices, their costs and all that, which is part of the turnover or transfer of ownership, is making sure that those values are entirely correct. So I don't call it auditing, but we're reviewing all the costs to get to that final number.
And those are, for lack of a better phrase, assets that would be transferred to EPE.
That is correct.
Are there any other assets associated with that interconnection that would also be transferred to E EPE?
I'm going to say not of substantial. When I say that, those costs include what we call network upgrades, which would be the control and protection, again, on the far ends of the lines at other substations. There are some assets associated with some transmission upgrades that will also end up on El Paso Electric's books as an asset. But the bulk of the money there is associated with the Otero substation.
Could I ask you to estimate those other transmission, a value for those other transmission upgrades?
I don't have the LGIA in front of me, but I'm going to make a guess that that is less than $2 million.
Thank you. That's all I had.
Thank you, Mr. Herman. Staff, Mr. Borman, do you have any cross-examination for Mr. Davis?
Thank you, Madam Hearing Examiner. Staff does not have any questions for Mr. Davis.
Okay. Mr. Davis, I have a couple of questions. Can you explain in what way the construction of the interconnection facilities contributed, if they did, to any delays that resulted in the amendment of the contracts?
For Buena Vista?
Yes, for Buena Vista, and then for Hecate, if they did contribute.
So for Buena Vista, the construction activities and the timelines, the impacts schedule-wise that were associated with I'll call the hot topic of the control cables, ultimately became the NextEra's issue. Since they were self-building, they assume, I'll call it, the responsibility and the risk of making sure that they met the timelines of the process. As looking backwards in time, even if the control cables had made their timing correctly, and we would have been done approximately 8 months ago or whatever, pre-peak of last year, there still were no solar panels ready to meet the rest of that activity. So I speak from their perspective, either way, they weren't going to get there. From the El Paso Electric side, we had met all our obligations and our facility requirements to be able to support. On the case of the Hecate, which was your second part of that, we actually engaged in an EPC contract some time ago. And one of the key reasons we had done so is we were concerned about meeting what was an aggressive timeline proposed by the Hecate people. And our confidence in using internal resources was that we should go out and find a solution that ensured our ability to meet the timeline that Hecate had been advertising. As we have progressed through that process, of their changing of their dates and their deliveries. All we have done is refine the EPC to have I'm going to use the word, a better, more complete approach to how we were going to go do things. In that process, we're not holding them up at all.
Okay. So with respect to the contract amendments, I understand that those are primarily to the PPA. Are there associated revisions to the LGIA?
On the Buena Vista side, there were little, if any, changes to the LGIA. On the Hecate, there was one fundamental change, and that is when Hecate first started with their PPAs, they actually had proposed 2 transmission lines to El Paso Electric. So that Verde sub would have actually been receiving 2 transmission lines. As they consolidated their activities, they now have 2 generating sources and 1 transmission line. So there was a revision to the LGIA in terms of configuration of the transmission providers, interconnection facilities, e.g. our substation. We eliminated a bay.
Did any of these changes impact the overall cost of the project? Or the Buena Vista project or the Hecate project? I mean, it sounds like for the Hecate project, it would be less expensive.
The build costs will be slightly less expensive. I would say on the Buena Vista, there's nothing material that would change. I would say more of our costs are associated with time than it is what I would call design cost of the substation.
I don't have anything further. Do you have any redirect, Mr. Wexler?
I do not. Thank you.
All right, I think that would conclude your testimony, Mr. Davis.
Madam Hearing Examiner,
Yes, Ms. Souls.
may I recross based on your questions and Mr. Davis answered?
Go ahead.
Thank you. Mr. Davis, when the hearing examiner was asking you about the control cable, and you were saying that it wouldn't have changed the timing, I think you said because there were no solar panels on site.
There were not adequate. There have been some solar panels there, but they would not have enough capacity to meet the terms of the LGIA, the generating capacity.
Okay, so you acknowledge there were 20 megawatts of solar panels on site.
I would acknowledge there were some amount of solar panels there.
Very well, thank
They're
you.
adjacent to us. We could look over the fence and see them down there.
Sure. One other question. When you talked about it became more a matter of time in terms of the cost, did I hear you say that was in regards to Buena Vista?
It's actually in regards to both. If the time stretches out, we still are applying project management resources, security. We're interfacing with their people, so we're still active in the process, even if they're not done. It's like extra innings in a baseball game.
And would you agree that the time costs apply to both El Paso Electric and to the seller?
Yes, we're typically both applying some amount of resources as we wait.
Very well, thank you.
You're welcome.
Thank you, Mr. Davis. I think you may be released at this time.
Okay.
I am thinking that we should take a short break and then we can continue perhaps with Mr. Reyes out of order as we discussed earlier. Ms. Stevens, would Mr. Reyes be available?
I believe he's been watching, and I'll check right this second. And I will track him down because I know he's here. He's going to be on a plane tomorrow. Thank you.
Okay, so we will take a 10-minute break and start at 2:52 with Mr. Reyes. So we're off the record for the next 10 minutes. Thank you. We'll go back on the record as soon as. Oh, and here is Mr. Lee.
Go ahead,
Yes.
Judge.
Thank you, Mr. Lee. I believe Mr. Reyes has entered the room. Is that,
Madam Hearing Examiner.
yes, Mr. Elliott.
Before we get going, I'm requesting that to be excused here shortly. I agree to be bound by any decisions you make in my absence and waive all cross-examination of the witnesses that might appear.
Your request is approved.
Thank you.
Elliott. You're welcome. So we are back on the record in the matter of 19-00099 and 00348 UT for a witness from the city of Las Cruces, Edwin Reyes. Mr. Lee, can you swear in Mr. Reyes?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
El Paso, or go ahead, Ms. Stevens.
Good afternoon, Mr. Reyes. Would you please give your full name for the record?
Full name is Edwin Reyes Jr.
And how are you employed?
I'm a consultant with Enchantment Energy Consulting.
And did you have the opportunity to prepare some direct testimony on behalf of one of your clients, the city of Las Cruces, in this proceeding?
Yes, I did.
Do you have in front of you a document that's been marked as CLC Exhibit number 2?
Yes, I do.
Is that the testimony that you prepared in this case?
Yes, it is.
Do you have any changes or corrections to make to that testimony at this point?
There were, I believe, 2 small corrections.
And I think if we go to page 13 of 19, we'll, the first one on the footers or the PDF documents.
On the what?
On the footers or the PDF document, the Bates stamping in the footer.
Yes,
Pardon
it's
me.
13.
13 of 19.
No, 15 of 19.
I'm looking at 13 of 19 and 15 and 14 of 19.
Oh, yes, yeah, there's a one correction in line 14 on page 13 of 19.
And is that just to strike a stray
Correct.
mark?
Yes, and then there is also one on line 26.
And I'm also looking at line 11 on the same page. Is there
And
a comma
yeah,
insert?
line 11, there's a comma added.
And then on page 15,
15 of 19.
which
Yes,
is
and line 2, there's an insert of the word were between there and days.
so it reads in October of 2022, there were days when.
Correct. And then in line 3, it should read was negative at less than minus 400 per megawatt hour. So striking that and inserting then.
And with those little corrections, Mr. Reyes, if you were asked the same questions today under oath, would you give the same answers?
Yes, I will.
No, is your testimony true and correct to the best of your knowledge and belief?
Yes, it is.
And with that, the city moves to admit CLC Exhibit number 2, Mr. Reyes's direct testimony.
Are there any objections?
No objections.
CLC Exhibit 2 is admitted. So we will now turn to cross-examination by El Paso Electric, Mr. Wexler.
Good afternoon, Mr. Reyes. I'm Carrie Olson
Oh,
from
Miss
EP.
Olson.
I'm going to be doing cross-examination. I still going
Miss
by
Olson.
Jeff Wexler on the Zoom link, but nice to see you again. It feels like we were just here.
Good to see you too. Yes, it was just a couple
Um,
of weeks, I think.
After a very long day so far, hopefully you'll be happy that I only have a few questions for you this afternoon. So hopefully we can move through this fairly quickly.
Great.
I want to start by just trying to establish a common understanding about the scope of this case. So I think on page 9 of your direct testimony, you recognize that in case number 19-00099 and 19-00348, the commission already approved the October 17th, 2019 PPA between EPE and Nextera for the 100 megawatt solar energy and 50 megawatt energy storage, the Buena Vista 1 PPA. Is that correct?
Correct.
And you recognize the commission has also already approved the March 2020 PPA for an additional 20 megawatts of solar energy, correct?
Correct.
And then the October 17th, 2019 PPA and March 18th, 2020 PPA between EP and Hecate Energy for 100 megawatt and an additional 50 megawatt solar energy, correct?
Yes.
And will you agree with me that the purpose of this hearing is just to evaluate certain amendments to each of those previously approved PPAs?
Yes, I agree.
Have you read through the proposed amendments to each of the previously approved PPAs that are presented for approval in this case?
Yes.
One of the issues you address in your direct testimony is control over the energy storage facility, and specifically page 4 of 19 of your direct testimony on line 21. You raise concerns over how the Buena Vista 1 PPA assigns control over charging and discharging energy during specific periods of the year. Is that accurate?
Yes, I do.
And will you agree with me that the provisions addressing control over charging and discharging energy are part of the original Buena Vista 1 PPA previously approved in case number 19-348?
Yes.
And can we also agree that the amendments that are presented for approval in this proceeding don't address or modify those original PPA terms addressing control of the charging and discharging of the battery or the solar facility?
Yes, I do recognize that.
And you also recognize generally that the Buena Vista 1 PPA is a contract between EPE and Nextera?
Yes.
And as a general matter, would you also agree that modifying any term of a signed contract or executed contract would require approval from both parties?
I assume so, yes.
You didn't testify on behalf of the city in the underlying proceedings where the original PPAs were evaluated and approved, correct?
That is correct.
Were you a consultant for the city in either of those underlying proceedings?
I was not involved in those two original dockets.
Okay. Are you familiar with the city's position and testimony in the original case where the BV1 PPA was evaluated?
Slightly. I didn't do a full review of that record, no.
Okay. Are you aware that in the original proceeding, the city had objected to the Buena Vista 1 PPA?
Yes.
And are you also aware, in that case, the city identified the PPA term allowing the seller to have control over charging and discharging the battery as a reason for their opposition to that original PPA?
Yes.
And I think we've already established that the original PPA was approved over the city's objections. The other issue I want to touch on briefly addressed in your testimony is the replacement power costs. And your testimony provides estimated replacement power costs, is that correct?
Based on the historical power market prices.
Okay. And the estimates provided in your testimony are based on the assumption that EPE would replace the solar energy with 100% purchase power. Is that accurate?
What I was calculating was an estimate based on the replacement from market resources. I mean, as it turns out, the gas market was fairly volatile at the same time. Prices were elevated. If I had to calculate an average price based on replacement resources that were coming out of El Paso's fleet, based on MPS 3 and 4 at a 9.9 and 9.3 heat rate, we would have seen about a 59, we'll call it a $59.94 average, which would have resulted in about 13.3 million as opposed to the 22 and 2.3 million as opposed to the 9. So yeah, I mean, I recognize that. The estimate was more to outline the fact that the delay is causing a significant additional expense to the city.
Okay, and I want to go into that a little bit more. And I apologize, your technical understanding of it probably exceeds my lawyerly technical, so I may be repeating some of the things you just said, but you would agree that EPE is in the best position to evaluate and determine how to replace that power based on the balancing needs of the utility, correct?
I assume that they would use an economic dispatch, or I mean, as it was outlined in I believe it was Mr. Martinez's rebuttal testimony. He describes the SCED, the
I'm sorry. He describes the
SCED, SCED. It's Security Constrained Economic Dispatch, which is a specific strategy for dispatching resources based on first reliability and then economic reasons. So yeah, no, I understand. Yeah, completely.
And so you're familiar with that rebuttal testimony. It sounds like, and you don't disagree that some of the replacement power could come from local generation.
I'd assume that they would have additional resources at much of the time. I mean, they obviously would have additional resources since they're still serving the load, and the resources that they contracted for are not online yet. So that would make logical sense.
And that there's times, particularly during the morning hours, I think Mr. Martinez pointed out, when the load is low and EPE would have sufficient resources to meet that load without any purchase power. You would agree with that?
I assume that they would be able to meet load because they're meeting load currently. And I don't know how they're meeting the load, whether that's with a combination of their existing generation portfolio and a mix of market purchases, or if they're fulfilling that with all of their own resources.
Okay, thank you, Mr. Reyes. Those are all the questions I have for you this afternoon.
Thank you, Ms. Olson. See, Mr. Elliott, I believe. Mr. Elliott, or did you have any questions for Mr. Reyes? Or are you out? No. All right, Ms. Souls, do you have any cross-examination for Mr. Reyes?
No, ma'am, I don't.
Thank you. Doña Ana County, Mr. Herman, do you have any cross-examination for Mr. Reyes?
No, Madam Examiner.
I'm sorry, your answer again? I didn't hear you.
I said no.
Thank you. And finally, Mr. Borman, any cross-examination of Mr. Reyes?
I have no questions for Mr. Reyes.
Mr. Reyes, following up on the purchase power conversation you had with Ms. Olson, on page 2 of your testimony, that would be Bate stamp page 4,
Okay.
19. Are these based on I guess I would call it speculation, or when you discuss the replacement of the power that would have been produced by Buena Vista or Hecate?
No, they're based on over the course of the last year and a half or so, but particularly last spring, I was involved in several RFPs. I was running several RFPs for different wholesale providers, and so that's a combination of mix of responses to the RFPs that we had received. Some of them do include following service and other services that are not just a block of power out of a solar facility, but at any rate, that's where they're coming from. So they are actual market offers that wholesale providers had provided to me for different a couple of different clients.
But you don't know, or do you know, whether EPE has actually expended funds to purchase replacement power or energy?
I mean, they have purchased some energy. How much they've purchased, I mean, I'd have to go back and do a line by line analysis of all their 550 filings for fuel and purchase power. I have not done that.
Okay. So this is if they were receiving the, just how much it would cost to replace the full production capacity for Buena Vista in particular.
Yeah, that's correct. And as I had indicated, I did after looking at Mr. Martinez's rebuttal testimony, did some calculations based on MPS 3 and 4, which I believe are a couple of their mid-merit generation facilities that would likely be on in those periods. They run at about a 9.9 and 9.3 heat rate based on historical Henry Hub gas, which I do understand that we're talking about SoCal line, or I'm sorry, El Paso line gas, but it's fairly close to Henry Hub, and so we would be looking at somewhere in the $60 range if they were actually producing all the replacement energy for the resources that they weren't receiving from the solar facilities.
But on page 6 of 19, I'm looking at line 16. You say that the proposed price increases
are reasonable, and that's based on your familiarity with the market?
Well, I mean, in the sense that they actually incurred a price increase, we have seen price increases in a couple of different RFPs. In fact, in the P&M resource replacements for San Juan and for Palo Verde 3, we saw some significant increases in the price levels due to the supply constraints and other issues. At the same time, we did have a couple of projects that had no price constraints, but in the two that I was, that I'm involved in, they were very specific to pricing and particular supply that had increased. And in this case, they'd already noted that for Buena Vista 2, most of the panels were already on site, so it's kind of hard to say that there's a price increase on panels, even with the investigation from the DOC, that there's going to be a price increase on panels on that particular project, because the panels were already on site, and they had already made a determination that they were not going to do any retroactive penalties. So at any cost, I mean, the $350 for that particular project doesn't make any sense to me.
I'm sorry, is that $3.50?
Correct. $3.50 per megawatt hour increase doesn't really make sense. I mean, and so like I say, is it reasonable? It was reasonable in terms of the overall market. I mean, that's about, we were seeing anything from a 6 or 7% up to about a 20% increase, depending on the particular phase of the project. So if the project materials hadn't landed stateside, we were seeing a much higher increase than for projects that had materials that had landed stateside.
Okay. And then what is your recommendation with respect to the battery storage system?
The battery storage system.
And that's with Buena Vista?
Correct. Yeah, it's Buena Vista. The issue I have with it, and obviously it would have been better to be involved in the original docket, but the battery system it's a capacity resource. It can be there to provide ancillary services, emergency. It can be a contingency resource under an N-1. They lose another resource, but not having control of it takes. I mean, if they don't have control of it, then they can't use it for all those other purposes. So it ends up being strictly a generation resource that has a block of energy that's available, that is at the discretion of the supplier to provide whenever the supplier wants to provide it. The way that the PPA is written, I mean, there is kind of a block, and it does serve to I'll say even out the generation profile for the end of the day, but it doesn't offer a lot of it diminishes a lot of the value that the battery system can provide in the peak months of the year.
Okay, but this is not part of the amendments that are proposed currently by EPE.
That is correct. It is not part of the amendment.
Okay. I do not have any additional questions. Do you have any redirect, Ms. Olson? I'm sorry, Ms. Stevens.
I do. Just a few questions here. Regarding the cost estimate that you offered, the $60 range, is it true that you did the calculations after reading Mr. Martinez's rebuttal testimony?
Correct. I recalculated a replacement cost based on specific resources in the El Paso portfolio, MPS 3 and MPS 4.
And did EP propose or offer a replacement cost estimate of their own in any of their direct testimony?
I don't believe so.
Did Mr. Martinez in his rebuttal testimony provide a different estimate of the replacement costs?
No, I just said it would be much lower.
And Olson raised about the, and hearing examiner raised too about the control of the storage being an issue that was resolved in the previous case. Is it true that what the commission approved in case number 1998 for Buena Vista 1 was a project that would come online in May 2022 at a price, a certain price?
That's the way I understood it.
And is it now, are we now looking at a somewhat different contract because the company has changed the commercial operation date, the price, and certain other terms?
I mean, to the extent that there was an amendment, yeah, I mean, some of the terms have changed via the amendment. Now, whether or not the amendment is approved by the commission would I guess that'll determine whether or not those amendments change the contract.
Do you believe that the commission at this point in time should be looking at the contract and the proposed amendments in complete isolation, or should be looking at the overall effect on customers?
My preference would be to be looking at the overall effect on all the customers, and instead of just looking at one particular element.
And EPE's proposed changes are the result of change in circumstances that had led them to not be able to deliver the original agreement. They and NextEra not to be able to deliver the original commitment on time and at the agreed upon commission approved price, right?
I mean, based on the testimony from Mr. Hawkins, the agreement for the extension and the additional then the price increase had more to do with NextEra shareholders left holding, apparently them thinking that NextEra shareholders were going to hold the bag because some costs went up and they needed to increase their price by $4 or for something, and then they agreed to the $3.50. That's the part that I get. Overall, that's the part that really doesn't make sense to me. I really don't care about the NextEra shareholders. They signed a contract. They said they were going to do something, and then they didn't necessarily bring forth any evidence that there was a significant cost increase. They just asked for a cost increase, and then said that based on Mr. Hawkins' testimony this morning, that it was because their shareholders were going to get left holding the bag for a project that had slightly gone underwater.
And would you look at page 5 of 19 of your testimony?
Okay.
Did you identify a different change in circumstances concerning EPE's imminent participation in the California ISO's Western imbalance market that warrants consideration of changing the storage control terms of the 2019 agreement?
You're referring
I'm
to
starting at page 5 of 19.
Yeah.
Paragraph that begins at line 11.
Yes.
Is that a circumstance that has changed since the commission approved the original Buena Vista 1 agreement?
I believe it is. I believe that El Paso, and I don't remember the exact date when El Paso made the decision to join the Cal ISO Western Energy Imbalance Market, but Now that specific issue is going to rear its head over the course of, as soon as they enter the market. We've been seeing some significantly volatile pricing over the course of the last year and a half. And back in October, saw like I state here, minus $400 per megawatt hour in the PNM LMPs, and I'm sorry, LMPs meaning locational marginal price, and $75 positive in the Palo Verde market in Arizona. So, a $475 spread between the two markets. So there is going to be some significant exposure that they're going to see as they enter the Cal ISO market, and taking a specific resource and having no control of that resource just adds to the exposure that they may see.
To the best of your knowledge, the commission didn't have this sort of information in its hands, at its fingertips, when it made the decision to approve Buena Vista 1, did it?
I would assume that they did not, because the PNM hadn't even entered the Cal ISO WEIM at the time. So it would not have been, probably was not even an element that was under consideration.
Thank you. That's my questions. I think the hearing examiner is muted now.
Sorry, I was coughing, so I had turned off my microphone. All right, I believe then that we've completed examination of Mr. Reyes. Mr. Reyes, thank you for testifying today in this matter.
And thank you, Madam
Thank you.
Examiner, and everybody else for allowing Mr. Reyes to testify today and not tomorrow.
Yeah,
Appreciate it.
thank you. I'll be on a plane. Thank you.
All right. Well, you are released, Mr. Reyes, and we'll return to El Paso Electric's case. If El Paso Electric, if you'd like to call your next witness.
We would call Matthew Behrens.
Mr. Behrens, would you please raise your right hand? You solemnly swear the testimony you're about to give, matter not pending, should be the truth, the whole truth, nothing but the truth. I'm sorry, Mr. Behrens, can you hear me? I cannot hear you, Mr. Behrens.
Can you hear me now?
Yes, sir.
I do.
Thank you, sir.
All right, go ahead, Mr. Wexler.
Thank you. Good afternoon, Mr. Behrens.
Good afternoon.
Can you please state your full name and spell your name for the record?
Matthew Kurt Behrens, MATTHEW, KURT, B as in boy, EHRENS.
Do you have before you what's been previously marked as EPE Exhibit 5?
Yes, I do.
That's labeled the direct testimony of you. Was this testimony prepared by you or under your direct supervision?
That is correct.
And I believe you have some corrections, is that right?
That is correct as well.
Can you please walk us through those corrections? I think on the copy the hearing examiner and parties have, those have been interlineated in red, but if you could just point them out, please.
Perfect, will do. Page 10, line 7. The Director Energy Solutions should be struck and replaced with a senior attorney for the company. Or excuse me, page 1, line 7. Page 1, lines 11 through 15, strike in its entirety, replace with, I am responsible for providing legal support for the company's New Mexico regulatory matters and other legal guidance as requested. Page 2, line 18, strike. Finally, from 2017 until I took my current position in 2022, replace with, from 2017 to 2021. Page 3, line 14. Although I am a lawyer, I am not an attorney, nor do I intend. Replace with, although I am an attorney for EPE, I do not intend. And, oh, I skipped over page 2, line 23, add. Finally, before returning to the role of senior attorney in 2023, I was the director of energy solutions, where I developed strategies to increase renewable energy generation on and facilitate the integration of distributed energy resources into EPE's system.
Many of those changes are related to your job positions, and I understand that you recently returned to an attorney position in the legal department for EPE. Is that right?
Yes, I was godfathered 3'd back into being an attorney for the company.
But when you negotiated with Hecate, it was not as an attorney. Am I right about that?
Depending on the timeline, when I negotiated the initial contract, I was an attorney for the company. As far as the amendments, I was not acting as an attorney for the company.
Thank you. And now with those corrections that you just identified, is your direct testimony true and accurate to the best of your knowledge?
Yes, it is.
If you were asked the same questions that are posed in your direct testimony, would you give the same answers under oath?
Yes, I would.
Madam Hearing Examiner, I move EPE Exhibit 5.
Any objections? Hearing no objections, EPE Exhibit 5 is admitted.
Objection. I have a quick one. I have a quick voir dire that I got myself lost on. May I ask one question of Mr. Behrens?
Go ahead.
Okay. I think when Hecate was notified, are you aware that Hecate notified EPE of delays in 2021? The commission was notified of in the course of case 2100 00111-UT. Say it out loud, please. Don't nod.
Yes, I apologize. I was waiting for a question.
Okay. Were you in 2021 when that was happening, the discussions with Hecate, were you involved as an attorney or as director of energy solutions? Or were you not involved at all?
In 2021, if memory is correct, I served as both an attorney during discussions, and then after stepping into the role as director of energy solutions, I was no longer functioning as an attorney. The shift occurred, I believe, in October of 2021. As such, anything done prior to October of 2021 was done as an attorney for the company. Post October 2021, it would be I was on the policy side of the house, so to speak.
Okay. Thank you. I have no objections. I'm assuming that Mr. Behrens is testifying as in his context as a non-lawyer. In your role as a non-lawyer, is that true? Were you testifying as in this case?
I am testifying in this case, not as an attorney.
Not as an attorney. Thank you. And I have no objection.
Exhibit 5 has been admitted. Mr. Wexler?
Mr. Behrens, do you have before you EPE Exhibit 6?
Yes, I do.
This is labeled the rebuttal testimony of Matthew Behrens. Was that rebuttal testimony prepared by you or at your direction?
Yes, it was.
You also have corrections to your rebuttal testimony, is that right?
Yes, I do.
Can you please walk us through those?
Yes. On page 1, line 7 through 8, the director of energy solutions should be struck and replaced with a senior attorney.
With that correction, is the rebuttal testimony true and accurate to the best of your knowledge?
Yes, it is.
If you were asked the same questions that are posed in your rebuttal testimony, would you give the same answers under oath?
Yes, I would.
I move EPE Exhibit 6.
Any objection? Hearing no objection, EPE Exhibit 6 is admitted.
With that, we would tender Mr. Behrens for cross-examination.
Thank you. Is Mr. Elliott here? Oh, seeing that Mr. Elliott is not, we will move on to the city of Las Cruces, Ms. Stevens.
Hello, Mr. Behrens. I think we kind of passingly met during an during a rulemaking hearing, but we've not actually met. So good to meet you.
Pleasure to meet you as well, ma'am.
I represent the city of Las Cruces in utility matters. I'd like to ask you, again, some of these questions go to really what your role was and what your information was. On your direct testimony at page 3, which is 5 of 13, you testify that on beginning at lines 9 through 10, and again at lines 15 through 16, you testify on lines 9 through 10 that you addressed the evaluation that EP conducted of its contractual rights under the Buena Vista and Hecate PPAs. And you're talking about the evaluation that was done in the spring of 2022 after, correct?
Oh, please continue your question then.
You're referring to an evaluations that EPE conducted in the spring of 2022. Is that right?
Yes, that would include evaluations done in the spring of 2022.
Include or be limited to?
Include.
Were there other things that you testify to that are not regarding Buena Vista that were not in the spring of 2022?
Well, as the line reads, specifically, I addressed the evaluation that EPE conducted of its contractual rights under the Buena Vista and Hecate PPAs. And so in that regard, if there were discussions on items outside of the spring of that year, yes, I was in, that is something that would be covered by me.
And were you here when this morning when Mr. Hawkins was talking about the fact that he was the lead negotiator on the amendments with Buena Vista and less involved with Hecate?
Yes, I was present when Mr. Hawkins gave that testimony.
Were you the lead for Hecate?
Yes, I was the primary contact for Hecate, and I would provide information to senior executive management, and they would then determine the best path forward.
And do you agree with Mr. Hawkins's testimony that the company utilized outside attorneys in the negotiation process that he was involved in, which would be the Buena Vista?
Yes, I would agree that we utilized outside counsel for the Buena Vista contract, and I believe we also utilized outside counsel for the Hecate PPAs as well.
On your rebuttal testimony, Exhibit 6, at page 4, and let me make sure sorry, I was sloppy about my notes, whether it's it's probably page 4 of your actual testimony. Yeah, this is page 6 of 23 at the very bottom. It begins on line 20. Carries over into the next page. Can you explain to me why your answer is prefaced based on your reading of the testimonies of EPE witnesses EPE witness Hawkins, and EPE witness Victor Martinez, did EP take into consideration delay damages, default provisions, and provisions regarding replacement environmental attributes? Why are you referring to their testimony instead of giving your own personal knowledge?
Well, looking at this again, as I previously conveyed, I was the primary point of contact. I would then provide the information over to Mr. Hawkins and Martinez. They then were the primary decision makers on this matter. And since at issue in this particular case is the decisions that they made, they provided that information in their testimony. And so that's why I gave the answer that I did.
So you're not testifying from you're testifying from your reading of their testimony, not from your personal knowledge. You're a fact witness here, right?
Yes, and I can attest to my own personal knowledge, but as to that question, I am conveying to you my mindset when I answered that particular question.
You're talking about what they testified to, though.
Yes.
Confused at what purpose that testimony serves, if any.
Well, I believe we were talking about, this was during the rebuttal. It was some particular questions were raised. And so in order to accurately answer what was going on for the purposes of of drafting rebuttal testimony, it was important to understand those particular facts. However, through my direct testimony, can provide that, the general, the matters outside of that particular question. Again, this was specific to rebuttal.
Going back to your direct testimony, which is very short. We agree, and the substance of your testimony really begins on bottom of page 6 of 13 and continues on through page 9 of 15. Can we sum up your testimony as saying that the decision that there were no remedies, contractual remedies available, turned on the conclusion that NextEra had not failed to meet a construction milestone?
Yes, NextEra had not failed to meet the construction milestones.
And this is because this is the construction milestone of May 1st, 2022 for complete construction, or are there other construction milestones?
When you refer to May of 2022, you're referring to the original agreement. Is my assumption correct?
Yes.
Okay. And so when I answered these questions here, I'm referring to the agreement that we have, which is the amended. Now, at the time that we were having these negotiations as well, they had not defaulted on any of the terms, the COD term, I should say. They had not violated the COD term at the point that the negotiations were started. But ultimately, you are correct. It turns on the fact that when you look at the direct testimony that I provided, it comes down to the fact that the amended PPA has a specific COD date that was not violated.
The amended PPA.
Correct.
You were at this point in time, I mean, look at your own questions. What did EPE conclude about that at that time about default? When EPE was evaluating the possibility of amending Buena Vista and Hecate, did it consider whether there was a default? Your testimony is about what was done between the time that Buena Vista first alerted you to their desire to change the terms of the agreements and the July 13th conclusion of the results. Is that right?
Yes.
And at that time, then you had decided, and those negotiations occurred from sometime according to Mr. Hawkins, in very late April into July. Is that right?
Yes, I believe that is the timeline.
And at that time, you considered that they had not violated the May 1st deadline, even though it was past May 1st?
Well, as I stated in my rebuttal testimony, we initiated the negotiations on that particular item prior to the May 1st deadline. And because we were negotiating in good faith, we would not take a position that they were in default while we were negotiating in good faith. Also, they were taking concrete steps to cure that delay, which is taken into consideration as well. And so ultimately, if we had decided that we didn't move forward with those amendments and that we were going to leave the contract as it stood, then at that point in time, I would say, yes, they would have violated if that was the case. However, the parties were able to negotiate in good faith an amendment, and here we are.
And the negotiations, you said we initiated negotiations. I believe you just said we negotiated with them. Did they come to you on April 26th, about a few days before the deadline, and tell you we want more money? And
I was utilizing the royal we, referring to EPE. I apologize for my use.
Yes. Okay. The royal we is that did the royal we El Paso Electric initiate negotiations before the deadline?
Yes. EPE.
And when did EPE initiate those negotiations?
I can't tell you an exact date, but I do know for a fact it was well before May 1, 2022.
We'll see what the other witnesses say. And your testimony, your rebuttal testimony about negotiating in good faith with counterparties, what did you do on behalf of ratepayers in your negotiation? Remember, you were not an attorney at this point. What consideration was given to the interests of ratepayers when you negotiated these revisions?
So first off, I think every action that we take as a company, we always take into consideration the best interests of the customers. And in this particular issue, what we were trying to do is effectuate two things. First and foremost, our goal was to ensure that we were providing customers with the renewable energy that we had contracted for initially under this PPA. And second, we wanted to ensure that if we were to effectuate the goal of securing that renewable energy for our customers, that we did so in the most cost-effective manner possible.
And you did that by are you familiar with Mr. Martinez's analysis? DCH3?
Yes, on a high level. Do not ask. I'm not familiar down in the formulations and nitty gritty, but yes, I do understand that there was an analysis done to show that yes, this is a good deal.
And is that the level at which you understood it?
Yes, that is the level that I understood it. At the end of the day, as the person negotiating, I have to turn to my subject matter expert, and my subject matter expert conducts an analysis and tells me that this is a good number. I have no reason to question my subject matter expert's analysis.
I thought your testimony was I thought the testimony, Mr. Hawkins's testimony, was that he was the primary negotiator, and your testimony was that you were essentially subject matter expert in renewable energy or energy solutions at that point in time.
Well, and again, this is the problem when you have two different sets of contracts. When it comes to
we're talking about Buena Vista. Buena Vista is the one that changed the price, right?
Yes, you're absolutely right. And again, I apologize, but yes, it was in fact Mr. Hawkins who was the lead on that.
And you just testified, though, that EPE does everything to protect its ratepayers. I'm asking you, as a part of the team what did you do to protect ratepayers?
I believe I answered the question in that we were trying to secure through these discussions the renewable energy that EPE had contracted for. And in securing that renewable energy, we would do so in the most cost-effective manner possible.
And did you make, during your negotiations, did you make any arguments to NextEra based on what was going on in the markets elsewhere?
I'm sure that that was raised. I know in my discussions while this was going on with Mr. Hawkins, I know for a fact that the markets were an item that we were looking at, that we were well aware of, and that yes, we were taking that into consideration. Again, apologize when I say we. Please do not confuse that with me being in the room with NextEra. I'm referring the royal we of EPE.
Well, I would like you to testify as the not so royal I, because you're a fact witness here, okay? So go back to your last answer. Were you in the room? Tell me things about when you were in the room, when you were involved in the discussions, not what you presume was raised because it should have been raised. Okay, let's stick to that. What you actually know, because you're a fact witness, that means facts. Got that? Okay. So what did you raise as part of the team to push back or to evaluate whether it was appropriate for NextEra to both extend the deadline and raise the price?
I am at a loss here because you are asking me, you've acknowledged that I'm. So EPE in these negotiations that I was a part of, as far as Mr. Hawkins would raise issues, I would converse with Mr. Hawkins about various issues. I can attest to that, and that's why I keep on referring back to those particular issues, because my conversations with Mr. Hawkins and with others in regards to this contract revolved around those two goals that I informed you about. Now, how much clearer I can be to that particular point.
Having identified those two goals, I'm asking you about the specific inputs that you personally are aware of, because you are your testimony seems to just say that we did the right thing based on the fact that they got us into the room to start discussions before the deadline, so we had no choice other than to forego our request to seek damages of any sort, to negotiate on the deadline. There's some negotiation on the price. You didn't. What did you contribute to these negotiations, Mr. Behrens? Remember, you were not an attorney then. I want to know what you contributed.
Again, as I previously stated, I would have conversations with Mr. Hawkins, getting a general idea of what terms were being discussed. Did that sound? Did that seem reasonable? I would be asked to, about this particular contract term, Matt. Do you know exactly maybe what we're trying to get at? So Mr. Hawkins again was the lead, but when we would converse, those would be the conversations that we would have.
Did Mr. Hawkins ask you about your knowledge of the cost impact on ratepayers during the summer and all of the remainder of 2022?
And did Mr. I apologize, I want to make sure I heard you correctly. Did Mr. Hawkins ask me my opinion about the costs that were being proposed to EPE by NextEra? Is that a fair and accurate summation?
No, that's not what I asked. I asked what the ongoing actual cost impacts on customers were as you went through this process of negotiating?
Now,
Starting from May 1st, when you expected that power to be in place at the contracted price.
well, I think when we talk about the reasonableness of the prices, we all know that that goes into calculating a rate which affects the customers. So but as far as talking about, is it a 6 cents increase on the average bill? No, I did not have that detailed of a conversation ever with Mr. Hawkins. I'm
Did you
not.
have that detailed conversation ever with yourself?
Excuse me, Ms. Stevens, can I please have one speaker at a time? Ask your question, please.
I think I interrupted his answer. Mr. Behrens?
Oh, gosh, I forgot where I was going. ADD brain, I do apologize. Oh, yes, I know what I said. I apologize. We did not get down to the granular level of determining a rate, and nor would we, because I am not a rate design person. If you were to have those granular level discussions, it would be with somebody else within the company.
Let me see. Were you part of the discussions or the evaluation based on your knowledge of energy markets or whatever it was? Were you part of the evaluation of the validity of NextEra's Mr. Well, I shouldn't say next. Were you involved in determining whether or not NextEra might actually so-called walk away from this agreement if EPE did not surrender more money?
As a general matter of discussion, yes, I was part of those, discussions.
And were those discussions based on any quantitative analysis?
I don't believe that. I don't remember seeing a series of Excel charts or anything to that effect. However, the discussions basically boil down to an analysis of what is the walkaway costs to them, and and given the fact that we know what that is, are we concerned that maybe based off of that cost, knowing the size of NextEra, knowing the fact that you were dealing with a market conditions at that time, those were the discussions that were had. Now, as to the reasonableness of what that particular cost was, I believe other people had more intelligent ways to opine on that than me. But that's what I remember, those particular quote unquote walkaway discussions.
And the walkaway discussion based on your testimony and Mr. Hawkins's was based on the maximum damages that you could recover under the security provisions of the Buena Vista 1 and 2 agreements. Is that right?
I'm not certain if I have that level of specificity in my testimony.
Maybe you don't.
Okay, I just wanted to make sure.
Okay.
But nonetheless, I can venture an answer on that nonetheless, because if you're looking at a walkaway, the common sense approach to that is to figure out what is the maximum amount that they would have to pay under the contract to get out of it. And so that's, I believe that's a fair, what you stated to me about utilizing the maximum amount of damages that we could secure under the contract. Yes, that would be what we would look at as the walkaway cost.
And did you take into consideration, you or people with whom you're talking, Mr. Hawkins or whomever, did you take into consideration the amount of money that NextEra had committed to building the Otero substation and the other transmission interconnection and upgrades?
I'm going to object. This is getting far afield from Mr. Barron's testimony. As he already testified, he doesn't provide that analysis. That testimony was provided by Mr. Hawkins and to a lesser degree, Mr. Martinez. And so if Ms. Stevens has questions about that, then she should direct it to the proper person.
Ms. Stevens? Do you have a response?
Mr.
objection.
Mr. Barron's claims that he advised as a team member on this process, and he seems to have some knowledge.
Well, actually, I didn't hear Mr. Barron say that he advised as a team member. Mr. Barron's testimony seemed to be more along the lines of his providing reports to senior members of management who would then make decisions with respect to how negotiations would proceed. So I'm going to sustain the objection.
Okay, I'll
Do you
go
have?
on.
Thank you.
I'm going to ask you about page 5 of your rebuttal testimony, I believe it is. I'm sure I've got the right. Page 3 is page 5 of 23 of your rebuttal testimony. And it's the line that begins on page 16, line 16, page 5.
Mhm.
And it reads, contracts are in essence instruction manuals outlining the actions and protections necessary for the parties to get what they bargained for.
Mhm.
You go on to say that basically they're subject to change when circumstances change on the next page. Is that pretty much what your gist of your testimony is?
Give me a second. I'm just reading the paragraph. I would say that my entirety of my testimony is not how you characterized it. And as far as this paragraph goes, I would say that that the summation of it can be that you negotiate around the facts and circumstances at the time, but you must recognize that things change, and that although you may win a particular contract point, winning that contract point should not be everything that you seek, because you ultimately have to remember the purpose of the deal that you are trying to strike. And so arguing and to take the approach of merely going after contractual terms can lead to Pyrrhic victories.
So let's go back to the end of your rebuttal testimony. No, it's not the very end. It is page 8 of 23. Well, let me follow up on that Pyrrhic victory point. How do you know, Mr. Barron's, that EPE got the best deal for ratepayers that was possible in with regard to Buena Vista? What makes you feel confident that you did?
Well, I would quibble over the best possible outcome, but I would say we got a very good deal for our ratepayers. And what I believe we're looking at here is the fact that, and again, I believe Mr. Martinez and others, Mr. Martinez can speak more eloquently and intelligently to this particular point, but as I understand it, that we are able to get the renewable resources in, although not on the exact date that we negotiated for, definitely faster than we would if we would have had to restart the process. Secondly, as far as costs go, the costs of doing a rebid and going out fresh, we got a good deal for the ratepayers as compared to that. And so that's why I believe I can say that we did right by our customers through this deal. But again, I strongly recommend that you follow up on that analysis, questions regarding that analysis with Mr. Martinez.
And I have a question. I have some questions for Mr. Schiestel, but I'll ask you because, again, you were in the role of being a non-lawyer, but you are a lawyer and you probably know how to use Westlaw or Lexis. What did EPE do during that negotiating period to determine whether the amounts that you were conceding to next year, and both in terms of time and money, were consistent with what was going on in the energy markets? Or tell me that wasn't the way you approached it.
No, we, as far as how we approached it by utilizing the resources that EPE has at its disposal. Again, I can't speak to the specific items that Mr. Martinez looked at, but I am almost positive that those materials would have included news articles, the utilization of S&P, as well.
Are you speculating before you go on?
Yes. I am purely speculating.
Okay.
I'm saying talk to Mr. Martinez.
Okay. Then I'm going to ask you to go to page 8 of 24 of your rebuttal testimony, lines 12 through 13.
Mhm.
And you conclude that in terms of moving past the fact that there was a May 1st deadline in the agreement, EPE follows the golden rule and does unto its contracting parties as it would have them do unto it. Do you feel that the golden rule applies in your relationship, the company's relationship with its customers?
Oh, absolutely. Absolutely, it does. And I believe, yeah, that's it. Absolutely. The golden rule applies to how we handle with our customers.
And would you have reached the same result in this negotiation if you believed that you would not be able to recover the extra $3.50 from your customers? Or some part or all of the $3.50?
And wait, I just want to understand the basis of it. So you're asking me, would we have moved forward if we would not have been able to recover any of the costs under the PPA? Is that or the amended PPA? Is that correct?
Would you? Well, that's one. Answer that question. Your question, and then we'll go on with it.
Okay. And as far as that goes, I don't believe that if EPE were the entity that had to cover all that, it doesn't make it. Well, again, I'm speculating here, but and so forgive me. The nature of the question calls for that, but looking at it there, that's not good public policy, because what you're doing is you're robbing your utility the ability to have capital at its hand to continue to move forward with the projects necessary that it needs to maintain a functioning utility. And so I would be perplexed that would be what we would reach, what we would settle on. But again, this is all just speculation on my.
Okay, we're going away from speculation. What constraints were during this negotiation with Next Era? What constraints were self-imposed by EPE on itself or Next Era on itself, if there was an assumption on both sides that the ratepayers would pick up all the consequences, dollar-wise, time-wise, REC-wise, renewable energy certificate-wise? What limiting factors were there to drive you to make a good deal if you thought that you believed that the ratepayers would basically suffer all the consequences and maybe the benefits.
Objection foundation outside the scope. We put Mr. Hawkins up as we've established here just recently. Mr. Hawkins was the lead negotiator on the Buena Vista, yet Ms. Stevens seems to be intent on trying to ask Mr. Behrens a number of questions about the direct negotiations with NextEra, which is not appropriate. We've already put that witness on. He's been off the stand already.
This is in the context of a question that testimony that Mr. Behrens himself offered on page 8 of 23 of his rebuttal testimony, alleges to be responsive to Ms. LaRock, city witness testimony regarding the Buena Vista amendment. He's talking about the Buena Vista agreements. He's talking about good faith and bad faith, and I'm asking him about good faith and bad faith.
But to which it's fair to ask about his testimony. It's not fair to ask about what EPE was doing in terms of negotiations with Buena Vista, because that is the testimony that Mr. Hawkins was provided for.
Can you rephrase your question and limit it to what would be within the scope of Mr. Behrens' testimony? I mean, I'm not sure what the question was.
Okay.
Actually, Ms. Stevens.
Mr. Behrens, looking at this testimony on page 8 of 23, and this is in the context of Buena Vista. You agree? You chose to respond to testimony about the Buena Vista negotiations, right?
You're saying page 8 of 23 of my
8 of 23 in your rebuttal.
Okay, I'm there.
Okay. And this is about the Buena Vista. You chose to respond to Ms. LaRock's testimony about the Buena Vista amendments, which indicates that you have knowledge and an opinion, right?
Okay.
Okay. Yes. Yes.
Yes.
Okay. So, and you testify that you would have been negotiating in bad faith to cause a counterparty to pay liquidated damages when you were negotiating in good faith. And I'm asking you, where in that good faith process were the parties considering the impacts on ratepayers as opposed to themselves?
Perfect. I can, again, just back to what I said, maybe 20 minutes ago, in regards to the fact that we were looking at the initial intent here of having timely built renewable resources for our customers and balancing that against the price increase. Ultimately, we wanted to get that ideally, no price increase at all would be the goal. But that's not the starting position that that NextEra came out with, and we had to meet to make sure that we were balancing the timeliness of the resource with the costs. And ultimately, those are the two factors that impact the ratepayers. Having that clean, renewable energy pumping into the system, and then the cost of that energy. Ultimately, those are the two factors.
And just to clarify one thing, which I believe you already testified to, the only quantitative analysis that you're aware of is Mr. Martinez's testimony, Mr. Martinez's analysis. Is that right?
In regards to the Buena Vista, I know that Mr. Martinez's was the analysis that was done to kind of verify the adequacy of the price, but I wouldn't dare say that would be the only factor. But again, I believe it'd be best to speak to Mr. Martinez, and also I believe Mr. Hawkins could tell you exactly all the items that were before him. Remember, I was merely one of many inputs that Mr. Hawkins had at his disposal.
You didn't do any other quantitative analysis. You didn't contribute that to the effort, did you? Quantitative, numerical.
Yeah, no.
Okay, that's my last question. Thank you.
Thank you, Ms. Stevens. Ms. Souls, do you have any cross-examination for Mr. Behrens?
Yes, I do. Thank you. Hello, Mr. Behrens. I'm Mary
Hello,
Lee
Ms. Souls.
Souls. I am a party in this case. And I'd like to start with your direct testimony.
Yes, ma'am.
Let's start at page 5 of 13, beginning at line 22. Just so that we're clear, you were directly involved in negotiating both the Buena Vista PPAs and both of the Hecate PPAs. Is that correct?
Negotiating the original PPAs, that is correct.
Thank you. Were you also involved in negotiating the respective interconnection agreements?
No, I was not. That would be handled by different attorneys on different attorneys.
Do you know who that would have been?
That would have more likely than not been the attorneys in the internal attorneys. Internal attorney would have been Miss Cynthia Henry, and we would have utilized outside counsel as well.
And did I hear you tell Ms. Stevens that you were negotiating on behalf of El Paso Electric, but not on behalf of the ratepayers? Is that correct?
Whenever I'm negotiating on behalf of El Paso Electric, I'm negotiating on behalf of the ratepayers.
So it's your testimony then that you were negotiating on my behalf?
We have an obligation to serve at a reasonable cost. And so everything that we do takes into consideration the fact that we have to make sure that the costs are something that the ratepayers, that's in the best interest of the ratepayer. So yeah, I believe that's something that is that we always look at.
Would it be reasonable to represent that in the negotiations with Buena Vista, where the Next Era shareholders was who they were trying to protect, and the other two parties would have been El Paso Electric shareholders and El Paso Electric's ratepayers? Would you agree with that?
Well, I mean, yes, I would agree that NextEra was negotiating on behalf of its entity, which ultimately involves its shareholders. And yes, EPE, when negotiating, is trying to negotiate the best deal for its business, which impacts its shareholders as well as its ratepayers, customers.
And would you also agree that while NextEra didn't get everything they asked for their shareholders, that El Paso Electric shareholders aren't carrying any of the cost of the situation, but the ratepayers are? Would you agree with that?
As far as how everything will flow through, then yes, I guess that would be a true, fair and accurate statement.
Very well. So perhaps you did a good job for El Paso Electric shareholders, but not such a good job for El Paso Electric's ratepayers?
Objection argumentative.
Ms. Souls, during the course of your cross-examination, you also should not be testifying. Do you have a response to Mr. Wexler's objection?
Only that I'm trying to figure out what Mr. Behrens really means when he says he's negotiating on behalf of El Paso Electric's ratepayers.
Well, I would ask that you present your question in a less argumentative fashion. Thank you.
Let's just move on. So please go to page 7 of 13 in that direct testimony at line 18. You state that there was no available remedy for default because none of the circumstances identified in the PPA as constituting a default had occurred. Is that your testimony?
Yes, that is my testimony.
And you also indicate Buena Vista and Hecate neither had failed to meet a construction milestone. Is that also your testimony?
Oh, yes, that was clearly an error that should have been fixed. That had, well, we don't know. Neither had failed to meet a construction model. Yes, that is correct. That is correct.
So let's go back to, I believe you told Ms. Stevens that yes, May 1st of 2022 was a construction milestone in each of the original 4 PPAs. Is that correct?
I'm not sure May 1, 2022. Well, I have to look at this at the schedules for each, but and if you want me to, I can take a look at that right now and tell you specifically. I just need to make sure I'm not speaking out of school. And so looking at the originals here, yeah, there's different dates. I just wanted to verify that's not all of them had the May 1, 2022 deadline.
You say not all of them?
Not all of them by function of the contract. Yes, that is correct.
What do you mean by a function of the contract?
I believe there was I believe it was in one of the Hecate agreements that should the LGIA not be negotiated, that the COD date shall be moved to December. And that's what I mean by function of the contract.
Then let's keep talking about the Hecate contracts. If that COD date was moved to December of 2022, would you agree that that has passed?
December 2022 has in fact passed. Yes, that is correct.
And how is it that with that revised date that there was not a failure to meet a construction milestone?
Because the parties have agreed, EPE and Hecate have agreed to an amended contract that has pushed out the COD date.
What about the other dates that were related to it?
The other dates that were related to the original agreement, all of those have been shifted as far as the amended agreements go.
So let's talk about, say, the material contracts that had a date of January 31st of 2022. And it's my understanding from what Mr. You're Mr. Behrens. Who did I just speak to? Mr. Davis. Sorry about that. Mr. Davis just told us is that those material contracts have not been executed. Is that a failure to meet a construction milestone?
Yes, that is in fact, what you described is in fact a failure to meet a construction milestone.
And is that not constituting a default?
Yes, that would, well, they would be in default under the terms of the contract. Yes, they would.
So your testimony here then is not quite, I mean, therefore, when you say that Hecate had not failed to meet a construction milestone, is that incorrect then? Are you changing that testimony?
No, I am not, because I refer you to the question immediately preceding my answer. What did EPE conclude at that time about default? As such, my statement is true and correct.
All right, at what time are we talking about, please?
What time so at that time about the default, so we are talking about, please give me one moment while I go back up. This would be when we were negotiating the amendments.
And that date would be approximately when?
That is a range of dates. And so you're looking at the spring of 2022 forward. And then those would, and I would consider negotiations to have been completed on the date that each party signed the agreement.
So in the spring of 2022, that would be after January 31st of 2022. Would you agree?
Or, God, I'm confusing. Yeah. That would be after January of 2022. Yes, I would agree that that would be the case. Yes.
So was there, on behalf of Hecate, a failure to meet a construction milestone?
And on that particular matter, yes, on that particular matter, if the material contracts were not executed at that point in time, then yes, indeed, that would be an active default at the time. However, looking at the contract, please remember that under the contract, ultimately what you look at is the ability to meet COD. That also informs the ability of how liquidated damages are paid. And so when you look at the liquidated damages section for the failure to meet the COD damages, what you do is, yes, you start accruing those LDs. However, you have an accounting once COD is met, or once they have achieved COD. If Hecate fails to deliver on COD, or excuse me, let's start with this. If Hecate meets COD, then any liquidated damages that were either paid or accrued go back to them. Or in the case of an accrual, we just wipe the slate. And if they fail to meet it, then at that point in time, those liquidated damages then become certain and payable. Definitively, EPE has a right to those particular monies.
Mr. Behrens, I want to go back to what we're talking about here regarding at that time, approximately April of 2022, and that you, EPE, concluded there was no available remedy for default. It's not, I'm still just talking about whether or not there was default according to the PPA.
Well, there was no.
Are you talking about Hecate?
I'm talking about, well, Hecate is the example that we're using. Yes, ma'am.
Okay, so this April 2022 example is Hecate.
That's, Mr. Behrens, isn't that when you're describing when you did the evaluation for both Buena Vista and Hecate that you're referencing in your testimony?
It would have been on or about that time that we would have been analyzing these contracts. Yes.
Thank you. So was there a default related to that construction milestone in the Hecate contract?
No, because again, we negotiated the PPAs. We negotiated the amendments, which then moved the dates that they had to achieve.
When did you negotiate the Hecate amendments?
That would have been in the time that I previously stated, around probably beginning around that same time frame, the March, April time frame, going all the way through. I believe those were executed. Well, I believe, let's actually look at the date of execution. I apologize. So looking at that, yeah, October 3rd, 2022.
So you're telling me that as of January of 2022, it took you until October to negotiate the amendments to the Hecate PPAs?
Yes.
And what triggered that negotiation?
The fact that we were aware, just like we were with the Nextera contracts, that there were issues due to the markets that were affecting their ability to meet the deadlines as originally agreed to. We had conversation, or not, Hecate had alerted us similar to the way that Nextera alerted us.
Is it your premise that an ongoing negotiation negates the existing contract and its provisions?
No, it does not negate it.
Then I want to ask again, if Hecate had not executed those material contracts by January 31st of 2022, Why is that not a default?
It is not a default because the parties were actively trying to negotiate, and you could view that as being an attempt. And also we do know that they were making adequate attempts to cure that. Remember, this is a fault of the market. They were trying to secure those panels and everything else that is necessary to complete the project. So they were making a continued effort to cure what was causing the default.
So did you hear me ask Mr. Davis questions about why the interconnection is not already complete?
I may not have been in the room at that particular point in time. I apologize.
So in your testimony, you talked about, let's see, on page 8 of 13, you're talking about whether or not there was a force majeure event, and you conclude there was not. Everybody agrees to that. Is that correct?
That's correct.
And at that point, apparently, based on where you're responding on page 8 of 13, EPE was evaluating the possibility of amending the PPAs, and you considered whether there was force majeure. Is that correct?
That is correct.
And then you mentioned that PPA provisions for delay damages. And you referenced where that is in each of the PPAs.
That's correct.
When I read those, they refer to the paragraphs in those areas that are related to construction milestones and extensions of the construction milestones.
Correct.
And you didn't reference that in your discussion. Why not?
Could you please clarify what you mean? I did not reference those in my discussion.
So subsequent in each of the contracts to the paragraphs related to delay damages. And the delay damages talk about they don't come into play if there's been a permitted extension of the construction milestones. But your testimony doesn't reference that, correct?
Well, I mean, no, it doesn't. My testimony doesn't specifically reference that particular item.
Is it your testimony that the provisions in the contracts related to permitted extensions of construction milestones, that's not relevant to the conclusion El Paso Electric came to?
I'm sorry, I apologize. Do you mind repeating your question? I humbly apologize.
Is it your testimony that the provisions in each of the contracts related to the extension of construction milestones and the required commercial operation dates, that is not relevant to the conclusion that there were no defaults or delay damages available?
I apologize. I am not trying to be obtuse.
Well, then let's look at one, shall we?
Please.
If you would go, let's stay with the Hecate 1, perhaps.
Perfect.
Which I believe you'll find in Mr. Hawkins' direct testimony. I'd like us to go to page 335 of 548.
I'm assuming you're meaning the specific site for section 4.3 of the contract, correct?
4.3, I believe, starts on the page before that.
Okay, yes. And so we're looking at 4.4 extension of construction milestone and the required commercial operation date.
Yes. Now, does this paragraph 4.4, is it any of the bases that El Paso Electric used to conclude that there were no default had taken place?
EPE considered the entirety of the contract when making that determination that there was no default.
I'm asking you about paragraph 4.4.
And we would have read 4.4, and I shouldn't say we would have read, I know I read paragraph 4.4 at that time. And it was a factor that was considered as well as any other relevant section of the contracts.
Is it the basis for concluding there was no default?
No, that was not the basis for concluding that there was no default.
So am I to understand you that in every case, the primary basis was that El Paso Electric was already negotiating changes to the construction milestone?
No, the reason that we do not have a default here is because we amended the contract. And through the amendment of the contract, no key dates were missed.
I'm asking you about the period before each of the contracts was amended.
Okay.
Would you agree that the Buena Vista contracts were amended in July of 2022?
Yes.
And that the Hecate contracts were amended in October of 2022?
Yes.
So in the period before those dates, when they were actually amended, did I understand you correctly that the reason there was no default as various construction milestones were being missed, that the reason was because you were already engaged in those negotiations?
Yeah, I would say that was partially, and mind you, I wouldn't say that it means there was no action that could be deemed a default, but I refer you back to the language there of continued effort to cure default. I would say that we were negotiating in good faith. Now, should those negotiations have fallen apart and the original contract were to stand, I would say that EPE would have gone after all of its contractual remedies.
Then do I understand you that it was a choice that El Paso Electric made not to claim a default?
Yes, it's a choice to not claim a default during this process. Yes, but but nonetheless, the facts as they stood, should the amendments not have been executed, it is not without a question in anybody's mind that there would have been, per that timeline, missed points, and yes, we would have been able to go after any of the contractual remedies that we had. Ultimately, though, we recognize the fact that this renewable energy is something that the commission wants, that our customers want, and that's why we moved forward in the manner that we did. We want that renewable energy. We want to make sure that we provide that renewable energy in a cost-effective manner to our customers, and in a timely fashion.
I'm sorry, the last part you said, you broke up.
I apologize. At what point did you lose me, sir?
In a cost-effective manner to our customers, and then you said something else.
Yes, and in a timely fashion.
Thank you.
Mr. Behrens, regarding the Hecate PPAs in particular, since there was no adjustment to the prices involved in Hecate, why were the amendments required?
Because we wanted to secure those very good prices that Hecate offered us.
I thought you already had those very good prices locked in.
And if we did not go down the path of getting the amendments that we did, we probably would have not had that resource. Hecate, again, could have walked away just like Nextera walked away. But I mean, not that they did, but like Nextera could have walked away. And so we have that same factor at play. This was a very good price. It still is a very good price from my understanding. If that price had been bid in to our most recent RFPs for solar resources, that price would be a winner.
And what is it about the amendment that means that Hecate won't walk away?
Well, this allows, the reason that we moved forward with the amendment and the extension of time is so that Hecate could secure the resources that it needed to execute the provide us the facility and the power at that very good price.
Let me ask you again. I'm not understanding what the amendments do that wasn't already in place.
And my answer is that it extends those dates, and it extends those dates, and we are more secure in the fact that Hecate will be able to provide it at the cost negotiated. That is that's what it facilitates. If the original timeline had stood, there was a good chance that Hecate would walk away and the customers would be denied the renewable energy that we had negotiated at a very good price.
Would you agree that from the modified December 31st of 2022, the original modification, that then there was also a modification that moved those, at least one of them, it wasn't clear, to May 1st of 2023, and that had already taken place? Would you agree?
Well, what are you referring to specifically?
Mr. Hawkins, in his testimony, which I could find if I need to, it indicated that one of the Hecates, that date had already moved to May of 2023.
I want to make sure I understand what your basis is. Are you claiming that under the terms of the original agreement, the COD had moved to May of 2023? Is that the basis of the question?
Yes, that's what I understood Mr. Hawkins to have testified to.
Then you misunderstood Mr. Hawkins' testimony, or what Mr. Hawkins answered. Mr. Hawkins, I believe, was referring to the fact that it had shifted to December from May, because that's the language that was in that particular contract. And I want to say that that would have been the Hecate 1 agreement, but I would have to find the specific language within the contract to verify, but that is what he was referring to.
I disagree. I think this is on page 22 of 548 of Mr. Hawkins' testimony.
Okay, let me pull up Mr. Hawkins' testimony. Please grant me a moment, please. Hawkins, perfect. And please direct me to the page number.
Well, I'm thinking this is the right place. 22 of 548.
I'm sorry, ma'am, you're breaking up. I'm thinking.
22 of 548 is where I'm headed.
Okay, I'm at page 22 of 548 of the PDF.
At line 8, starting on 7, Hecate 2 had a contracted commercial operation date of May 2022, which was extended by mutual agreement to May 2023.
Okay.
Do you see that?
Yes. Thank you for the clarification and telling me. Yes. Now, as far as that goes, yes, that would be correct. And yes, this was not. I was speaking earlier of a completely different contractual item there. So yes.
Then let me ask my question again, which is, if that was possible in the original PPAs. Why is an amendment required? Why isn't there simply mutual agreement to extend it to June of 2024?
Well, I believe at this point in time, we were looking at still securing an amendment. This is of a shift like that. I definitely would. I think we wanted to have the commission not only on notice of that, but also approve that shift.
So is it your testimony then that the purpose of the amendments is to inform the commission?
No, it's to get the permission for all the changes that are in the amendments.
And are there any additional protections for ratepayers built into the amendment? Or is it just memorializing these mutual agreements?
No, there are additional protections for the ratepayers, the customers in the amendments. We increased the delay damages from $1,500 a day to $2,500 a day. We increased the security, the required security by a significant amount for each of those contracts. We upped the reporting that was required, that they were required to provide EPE. So I would say, yes, we looked at ensuring that there were additional customer protections built into any amendment that we entered into with Hecate and Nextera.
So Mr. Behrens, you said you increased the delay damages.
Mm-hmm.
But if El Paso Electric persists in never finding an event of default, how does that help?
Ms. Souls, that's really very speculative. I think, you're talking about something that may or may not occur in the future if these amendments are approved by the commission. So I'd ask you to move on.
See what else I have here. I have no further questions.
Thank you, Ms. Souls. Ms. Lynch, any questions on behalf of CCAE?
No, ma'am.
Mr. Herman here. Mr. Herman, any questions on behalf of Doña Ana County?
No questions, Madam Hearing Examiner.
Thank you. Mr. Borman, any questions on behalf of the utility staff?
Staff has no questions for Mr. Behrens.
Thank you, Mr. Borman. Mr. Behrens, I do have a couple of questions. You've provided a revised amendment number 1 to the Hecate contract, is that correct?
That is correct.
And can you identify what the differences are between the amendment that was originally provided in the filings in this document?
Yes, I can. And moreover, I believe I would not be speaking at a school to say that we can provide a written red line after this is done. That way it is clear what those red lines were. Let me move to the contract. Please bear with me, and I can identify those for you. And so the changes would be an increase in the security fund, first and foremost. And so let me tell you those numbers as presented there. And give me 1 second while I go back to the original. Apologize. Article 11, I believe, in this contract. Oops, wrong. And so looking here, we have, yes. One moment. Yes, we had the increase to $15 million on the security fund overall for this particular agreement. And the other line that was changed, and also the subsequent $10 million was increased as well. That was down below the remainder of the required amount, $10 million that was increased. And then for point of clarity, the Hecate had requested a specific item that we had missed. And again, all of these are items that we had already negotiated. These were just errors in the final contract. We had a meeting of the minds. It's just we were rushing to get everything signed, and I think there were some errors. In fact, just for further clarification, if you remember, the amendments, I believe, had 2 instances, in fact, of this paragraph A, and so we were just wiping it, making sure it was the appropriate one. And the additional language that was requested by Hecate was on looking at section 13.1. And that would be F, and that would be on my page 15 of 23 is where the new language would have been instituted. Yes, and so notwithstanding anything to the contrary in this section 13.1, no construction event of default shall occur or be deemed to have occurred at any time during which seller is paying delay damages pursuant to section 4.4. Hecate had expressed a concern that, hey, there seemed to be a disconnect in the language of the contract. And so they wanted that assurance that, hey, if they're paying liquidated damages, that we weren't gonna up and say, that's it, we're taking our ball and going home. And I believe there may have been some other smaller ones, but those were the 2 key significant changes that were made there.
Okay. So Mr. Wexler, if you could consider that a bench request
Understood.
for a red line on the Hecate amendment to the PPA.
Yes,
All right,
we'll
thank
provide
you.
that.
And then I don't know whether this is something that you're aware of, Mr. Behrens, but Mr. Reyes's testimony included a discussion of what costs could have been incurred by EPE having to purchase replacement power as a result of these projects not being online. Do you know whether or not EPE purchased replacement power, or would that be another witness?
That would definitely fall under Mr. Martinez's bailiwick. I honestly don't know.
Okay. And so then your testimony is that EPE never considered Hecate or Next Era to formally be in default because you were negotiating contract amendments, even though some deadlines may have passed during that time.
Yes, even though some deadlines may have been passed, the way that I would categorize it in my head is that we had a potential default. But as we were negotiating in good faith to get to a resolution of this matter to preserve the underlying renewable resources that the company had sought, that is why no trigger was pulled to cross the Rubicon into this is a default, therefore you must pay me now.
I don't have any further questions for Mr. Behrens. Thank you. Mr. Wexler, do you have any redirect?
Briefly, Mr. Behrens, I want to start. Ms. Stevens asked you a whole lot of questions about Buena Vista, but to be clear, am I correct that it was Mr. Hawkins who was the lead negotiator on Buena Vista?
Yes, that is absolutely correct. And as I stated multiple times over in my discussions with Ms. Stevens earlier.
Now, you were the lead negotiator or the primary point of contact, I think you described it as, on Hecate, is that right?
That is correct.
Many of Ms. Stevens' questions, in fact, most of them had to do with the cost increases for Buena Vista. Were there any cost increases for Hecate?
No.
Turning then to the questions that you, the various hypotheticals that you had with Ms. Sewells about the default. And I think you were talking about, she specified we're talking about the Hecate project, is that right?
That is correct.
And I find it very difficult to talk about these contract provisions in the abstract. So let's take a look at the Hecate contract, shall we?
Yes.
And this is DCH 7. So this is Hecate 1. Now let's start at page 334 of 548. This is Article 4, pre-commercial operation, section 4.1, and I'm going to direct you to D.
I am there.
Okay, and you had some discussion with Ms. Souls about the extension of the commercial operation deadline to December 31st, 2022. Do you recall that?
Yes, I do.
And you see that language provided here in that section D?
Thank you very much. My memory was failing me on where the exact location of that within this particular agreement.
Okay, and now let's talk about default, because I think most of your discussion with Ms. Souls was about default. So let's turn to Article 13, which is page 356. And now we're talking about construction events of default. This is section 13.1. And then if you turn to the next page, page 357 of 548, and there you see under subsection E, I think this is the default that we're really talking about. Seller fails to meet any construction milestone. And then there's some provided language, including notice that has to be provided and that sort of thing. Is that's the default section here?
Correct.
Okay, and now let's go to the construction milestones. So now we're turning to page 390 and 391 of 548. This is exhibits A1 and A2. Are you there with me?
I am there already.
Okay, and we saw that subsection 4.4D, which said because of, as you testified, as Mr. Hawkins testified, we're dealing with exhibit A-2. Is that right?
That is correct.
And now if you scroll down to the milestones, you can see the various milestones, and just below 5, we can see their commercial operation date, December 31st, 2022. You see that?
Correct. Yes, I do.
And so at the time you were negotiating these Hecate amendments, and that was what, April, May of 2022, is that right?
That is correct.
Had that commercial operation date been violated?
That one had not, that particular milestone had not been violated. That is correct.
And so this Hecate PPA 1, they were not in default, is that right?
Yes, they were not in default. And as again, I explained to Ms. Sewells that ultimately is the biggest determining factor for the payment of liquidated damages.
Thank you. I have no further questions.
Is there any recross? All right. Hearing none, I believe then Mr. Barron's testimony is concluded today. And we can start tomorrow morning with EPE's fourth witness, which will be Mr. Martinez or Mr.
It will be Mr. Martinez, followed by Mr. Schichtel.
All right, so I think since it's 5 p.m. and we're clearly not going to finish today, we'll go ahead and conclude today's hearing. We'll be going off the record and we will be reconvening tomorrow morning at 9 a.m.
Madam Hearing Examiner, this is Anastasia.
Yes.
I wanted to apologize. I belatedly, just a little while ago, uploaded the two exhibits 13 and 14 with the correct labels, but I didn't take out the old ones because I'm not sure I know how to do that.
Oh, I think I did it, but I'll double check
You
them
did,
tonight.
yeah. If you didn't, I mean, just look and match the PDF number to the first page with the big, the label there. And I would just ask that, you can, tomorrow morning, you consider ruling on those 3, 13, 14, 15, which did not need a change. Just 13 and 14 were the ones that were inverted.
No, it looks like they have been corrected. And I did delete the old
Oh, great.
13, 14. And so, okay, so we'll take that up in the first thing in the morning. Thank you, everyone. Thank you, Mr. Lee.
Thank you.
Everyone have a good
Thank you.
evening.